Okay, we are now live and on the record for Monday morning's docket for June 27, 2022, the civil docket. And Attorney Ruben Ramirez, what do you have, sir?
Yes, good morning, Your Honor. We are here on a status conference hearing for a motion for the case and a motion to compel a deposition. Rui Mireles is the plaintiff's attorney.
Good morning, Your Honor. Rui Mireles here for the plaintiffs.
Okay, and what number is that on the docket, gentlemen?
That is number 45, Your Honor. And for the record, Ruben R. Ramirez on behalf of the defendant.
Okay, that's CL 192570-I, Jose Manuel Valderas et al. Versus Samuel Rangel. Okay, and what is the announcement?
Rui?
Sure. I mean, the announcement basically is that, we did file a motion to compel. Unfortunately, the defendant did not appear for his deposition, and we're going to ask to move on and move on with a trial date, and if the defendant decides to testify during trial, we would propose that he would not be allowed to testify unless he appears for a deposition.
And of course, Your Honor, we would as far as the deposition goes, we did make contact with our client. As you know, as most insurance provisions call for the duty of the defendant to help defend and participate in his defense. So I will say he is adhering to those, for the record, he is adhering to those requirements and stipulations. He was not able to make his deposition for whatever reason unknown to our office, but we had been in contact with him.
Okay, do you all already have a trial setting?
I do believe, no, I don't see a trial date on here.
I don't think we do, no.
Okay, so what are you all missing as far as this? Is just your depositions? How about the rest of your discovery?
We've done everything else. We've exchanged a written discovery. The defendants have taken the depositions of both of my clients. So I think this case is basically ready for trial.
That is correct, Your Honor.
Then go ahead and file your motion for a DCC so that you can get that set up. And then I guess the issue with respect to whether or not the defendant makes himself available before then is going to be really up to Mr. Ramirez's client. So if you need to have your motion to compel heard before then, just file an order setting hearing.
Yes, Your Honor. Sounds
All right. That concludes my business with this honorable court. May I be excused?
Yes, sir.
Me too, Your Honor.
Okay.
Thank you.
All right. Before we move on, so Ms. Olson, are you here on all those motion for default judgments?
I am here on 14 cases, Judge. It's a mix of both status hearings and defaults.
Okay. So if you want to log back in so that you're not waiting, if you have other things to do, you can check with us in about 20-25 minutes.
Okay. All right, Judge. I can just, I'll just mute. So I'll be here on.
Okay.
If that works. Thank you, Judge.
All right. Okay. All right, Ms. Orellana, what do you have?
Good morning, Your Honor. I have number 19. It's a friendly suit.
CL 23878-I, Maria Pineda, Pineda versus Diana Lopez.
Yes, Judge, and Tiffany here for the defendant.
Good morning, Your Honor. Melissa Carranza here, guardian ad litem for the minors.
Okay, and is it ready to move forward?
Yes, Your Honor.
Okay, and who is your client? I mean, is your client on? I'm sorry.
Yes, Maria Pineda. She is logged on.
Okay, Ms. Pineda, can you hear me? Maria Pineda, can you hear me?
Sí.
I'll need the services of an interpreter, Your Honor, please.
Okay, so which one is your client? Is she the one appearing with the children?
Yes, she's wearing pink.
Okay, Ms. Castañeda, please ask her if she can hear us.
¿Nos escucha?
Sí.
Yes.
Okay, have her raise her right hand.
Levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Lo juro.
I swear.
Okay, she can lower her hand.
¿Puede bajar su mano?
Go ahead.
Thank you, Judge. Ms. Pineda, can you please state your full name for the record?
Señora Piñeda, por favor, dice su nombre completo.
María Pineda.
María Piñeda.
And you are the mother of minors Ian and Sylvia Pineda, correct?
Y usted es la mamá de Ian y Silvia Piñeda, ¿correcto?
Correcto.
Correct.
And we're here today because of an auto accident that happened on October 7th of 2019 here in Hidalgo County, correct?
Y estamos aquí por un accidente que ocurrió el día 7 de octubre del 2019, ¿correcto?
Correcto.
Correct.
As a result of that accident, Ian and Sylvia were both injured, correct?
Al resultado de ese accidente, Ian y Silvia, los dos salieron lesionados, ¿correcto?
Correcto.
Correct.
And they both received treatment for those injuries, correct?
Y los dos recibieron tratamiento por esas lesiones, ¿correcto?
Correcto.
Correct.
And today their injuries have mostly resolved and they are doing well?
Y para hoy, sus lesiones han mejorado y están mejor los niños?
Sí.
Yes.
And we're here today because you have reached an agreement with the defendant on both of their behalves, correct?
Y estamos aquí porque usted ha llegado a un acuerdo con los defendientes, ¿correcto?
Correcto.
Correct.
To Ian, excuse me, they've agreed to pay $7,450, correct?
Para Ian han llegado a un acuerdo que van a pagar $7,450, ¿correcto?
Correcto.
Correct.
Of that amount, you're asking the court to pay $3,792.66 to the law office of Ezequiel Reina for medical expenses, case expenses, and attorney's fees, correct?
Y de ese dinero, usted está pidiendo que la corte pague $3,792.66 para la oficina de Ezequiel Reina y los gastos médicos, ¿correcto?
Correcto.
Correct.
$138.03 will be used to pay his Medicaid lien, correct?
Y 138.03 se van a usar para pagar el lien que tenía con Medicaid, ¿correcto?
Correcto.
Correct.
The remaining balance of $3,519.31 will be deposited into an interest-bearing account in the registry of the court for the use and benefit of the minor child, correct?
Y el resto del dinero, que es $3,519.31, se va a poner en una cuenta de vega de intereses para el uso del niño después, ¿correcto?
Correcto.
Correct.
As to Sylvia, they've agreed to pay $17,950 to settle her case, correct?
Y tocante a Silvia, han llegado a un acuerdo que van a ser $17,950, ¿correcto?
Correcto.
Correct.
$12,778.53 will be paid to the law office of Ezequiel Reina for medical expenses, case expenses, and attorney's fees, correct?
De ese dinero, $12,778.53 se van a pagar a la oficina de Ezequiel Reina para los costos médicos y costos del caso, ¿correcto?
Correcto.
Correct.
$244.65 will be paid to Medicaid to cover her lien, correct?
Y 244.65 se van a usar para pagar el Medicaid lien, ¿correcto?
Correcto.
Correct.
And the remaining balance of $4,926.82 will be deposited into an interest-bearing account in the registry of the court for the use and benefit of the minor child, correct?
Ms. Orellana, can you repeat that amount, please?
$4,926.82.
Y el resto de $4,926.82 se va a poner en una cuenta con intereses para el registro de la niña, ¿correcto?
Correcto.
Correct.
You realize that once the judge approves these settlements, you will not be able to come back and try to reopen these cases, correct?
Sí, usted sí entiende que cuando la juez rende cuenta en este caso, ya no puede venir a abrir el caso otra vez, ¿correcto?
Correcto.
Correct.
And the money will be deposited into the registry of the court for the use and benefit of each child, and you will not be able to withdraw these monies without permission of the court. You understand this, correct?
Y usted sabe que el dinero se va a poner en el registro de la corte y no puede venir a sacar ese dinero antes, ¿correcto?
Correcto.
Correct.
And you understand that we are here today to announce a settlement and you are asking the judge to approve these settlements, correct?
Y usted entiende que estamos aquí para anunciar un compromiso y usted entiende el compromiso, ¿correcto?
Correcto.
Correct.
I have no further questions, Your Honor. I pass the witness.
Okay, any questions, Mr. Tiffany?
I'll let the ad litem, Melissa, would you like to ask anything?
Okay, Ms. Carranza, any questions?
Yes, Your Honor, briefly, and I apologize if you hear some roads. I'm actually traveling out of town right now. Can you hear me okay?
Yes.
Okay. Ms. Pineda, my name is Melissa Carranza. Do you recall visiting with me prior to today? Regarding
Señora
this,
Pineda, mi nombre es Melissa Carranza. ¿Usted recuerda haber sido entrevistada conmigo?
Sí.
Yes.
and Ms. Pineda, Ms. Orellana, your attorney and your children's attorney just went over the settlement amounts with you. Did you understand those amounts?
Ms. Pineda, la señora Orellana, que es su abogada, acaba de repasar con ustedes las cantidades del caso. ¿Usted está de acuerdo con las cantidades?
Sí.
Yes.
And are you voluntarily entering into the agreement on behalf of your children today?
¿Y usted está entrando a este acuerdo voluntariamente?
Sí.
Yes.
Do you believe this this settlement is in the best interest of your children?
¿Y usted cree que este acuerdo es el mejor interés para sus hijos?
Sí.
Yes.
You understand that you have the right to take this case to a jury trial, but you have chosen to settle this case today, correct?
Sí entiende que usted tiene derecho de llevar este caso a un juicio por jurado,
Sí.
pero usted ha decidido arreglar el caso hoy, ¿correcto?
Correcto.
Correct.
And you understand that a jury could award you the same amount, more, less, or no money.
¿Y usted está de acuerdo que un jurado podría darle más, menos o nada de dinero, correcto?
Correcto.
Correct.
And knowing that, Ms. Pineda, you are giving up your right to a jury trial on behalf of your children, is that correct?
Y Ms. Piñeda, y sabiendo eso, usted está renunciando a ese derecho, ¿correcto?
Correcto.
Correct.
And after we visited Ms. Pineda, you indicated that both of your children, Ian and Sylvia Pineda, have recovered well from their injuries, is that correct?
Después de la visita, Ms. Piñeda, usted me dijo que los dos niños se han recuperado de las lesiones, ¿correcto?
Correcto.
Correct.
In fact, both of your children seem to be pretty active today, correct?
Sus dos niños están muy activos a hoy, ¿correcto?
Correcto.
Correct.
Judge, I have had an opportunity to visit with Ms. Pineda. We've discussed extensively the injuries that the children sustained, and she has indicated that they have recovered well from their injuries. She doesn't believe they're going to need future treatment at this time, Judge. Having reviewed all of the settlement documents, it is my recommendation to the court that this is in the best interest of these minor children, and therefore I am asking the court to approve the settlement as pronounced and the numbers as dispersed by Ms. Orellana.
Okay, Mr. Tiffany, any further questions?
Just briefly, Judge. Good morning, ma'am. My name is Alex Tiffany. I represent the other driver who was involved in this accident. You understand that?
Buenos días, Ms. Pineda. Yo soy Alex Tiffany. Yo soy el abogado del otro manejador.
Buenos días.
Good morning.
So I know you've had a chance to meet with your attorney, and you understand the terms of the settlement as far as the amounts that were just discussed?
Yo sé que ya se entrevistó con su abogado y usted está de acuerdo con el plazo de liquidación que están en el caso este.
Sí.
Yes.
And you understand that the amounts that your children will receive will be placed in the registry of the court?
Y usted ya sabe que las cantidades que les van a otorgar a los niños se va a poner en el registro de la corte, ¿correcto?
Correcto.
Correct.
And you understand that your children will have to come to the court to recover those funds once they turn 18.
Y usted entiende que los niños van a tener que venir a la corte a recuperar ese dinero cuando ellos cumplan 18, ¿correcto?
Correcto.
Correct.
And you understand that you're asking the court to approve this judgment and that it's in the best interest of your kids?
¿Y usted está de acuerdo que está pidiendo que la corte otorgue este acuerdo por el mejor interés para los niños?
Correcto.
Correct.
And when Ian and Sylvia turn 18, they won't be able to make another claim regarding this accident. Do you understand that?
Y cuando Ion y Silvia cumplan 18, ya no pueden venir a pedir más dinero por este caso, ¿correcto?
Correcto.
Correct.
Okay, I have no further questions. Thank you for your time, ma'am.
Okay, anyone else? All right, then with no further questions, and Ms. Carranza, have your fees been already taken care of or negotiated?
Judge, I have not had an opportunity to discuss them with Mr. Tiffany, but I'm certain we can agree on that. If you would like to send us to a breakout room now, or we can get back with the court with that number.
Judge, we can agree and put it in the order, and we can agree to form and all this, sign it and refile it for your approval.
Okay, that's fine. Then the court is taking judicial notice of all the documents in the court's file and approving the settlement agreement as testified to on the record by Ms. Pineda. And as soon as you circulate that order for signature, go ahead and submit it and I'll sign off on it.
Thank you, Judge.
Okay, Ms.
That's all I have before this honorable court.
Yes, ma'am. Okay. Ms. Castaneda, please let Ms. Pineda know that she is excused and that it has been approved. Ms. Castaneda, you're on mute.
Ms. Piñeda, la corte ha otorgado su caso y ya se puede retirar.
Thank you, Judge. I have nothing further. May I be excused?
Yes,
Thank you,
Have a
Judge.
good day, Judge. Have a good day.
thank you. Okay, Mr. Quintanilla, what do you have, sir?
Your Honor, good morning, Judge. I have number 41 on your court's docket, and I represent the defendant, Your Honor. This is a status conference hearing. Just so the court can know, I did communicate with Mr. Santos. He was going to be out of pocket today, Judge. But the announcement is that we mediated this case with Bill Garza on June the 3rd. There's a mediator's proposal that's been circulated, Judge, and we're pending. I'm very positive we can get it done, Your Honor. We're not there yet, but we're going to get it done. That's my wish.
Okay, that's on CL 181247-I, number 41 on the court's docket, Jesus Zuniga et al. Versus Adrian Garcia Chavez et al. And I'll go ahead and give you all an opportunity to circulate that mediator's proposal and I guess mull it over.
Yes, sir.
I am going to set you for September the 12th at 9:30. That will be in person. If you have something before then that takes care of that setting, then don't worry about it.
All right. September 12th, 9:30 in person.
Yes.
Thank you, Your Honor. You have a wonderful day, Judge. May I be excused, Your Honor?
Yes, sir. Thank you. Likewise. Okay, Mr. Tijerino, what do you have?
Your Honor, we have a status conference, also number 55 on your docket, Cantu versus Garza. And Mr. Rick Garcia is on the other side.
Yes.
CL 212583-I, Emilio Cantu et al. Versus Eliu Garza. Okay, Mr. Garcia, are you here?
Yes, ma'am. I'm here.
Okay, and what is the announcement?
We have depots coming up in August, Your Honor, and then as soon as depots are completed, we are going to mediate the case. And I believe there's already an order on file regarding mediation. So I think we have.
When do you
I think it was
anticipate in
Mrs.
mediating
Carranza.
the case?
What's that?
When do you anticipate in mediating the case?
Within 30 to 45 days after depositions, Judge.
Okay, but do you have dates for depositions yet?
Yes, Judge. We have depositions set for August 8th, I believe, and August 11th.
Okay, so then you probably won't be ready to mediate until the beginning of October?
Really, we could do it in September, late
Okay.
September.
All right, then let's come back on October the 3rd at 9:30 and see if you've settled the case, and if not, what the next step will be.
October 3rd at 9:30. Thank you, Your Honor.
Thank
Okay.
you.
Anything else?
Nothing else, Your Honor.
No.
All right, thank you. Okay, Mr. Alanis?
Good morning, Your Honor. James Alanis appearing for the Tejirina Law Group Judge on behalf of the plaintiff Fabian Ibarra. I believe it's number 54 on the court's docket, set for a status.
Oh, congratulations, Mr. Alanis. I didn't know you had left the public defender's office.
Yes, Judge, been here for about a month now. It's gone by fast.
Wow,
Thank you, Judge.
welcome to the civil side.
Yes, ma'am.
Okay, what number was that again?
Number 54, Your Honor.
Okay. CL 21-2380-I, Fabian, Favian, Ibarra, Ibarra versus HEB.
That's correct, Your Honor.
And who is here for the defense?
I'm not too
No
sure.
one? Okay, what is your status?
Judge, we have a scheduled mediation for August 29th, Your Honor.
Okay. Any deposition set?
Not that I'm aware of, Judge. I know that we're set to, I think it's going to go straight into the mediation.
Okay, who are y'all mediating with?
I believe the mediator, Your Honor, I apologize, Judge. I don't have that in front of us.
Okay, so you're mediating on August the 29th?
That's correct, Judge.
Okay, let's come back on September the 26th at 9:30.
Yes, ma'am. And that's all I have for today, Judge. May I be excused?
Yes, sir.
Have a good day.
Thank you, likewise. Okay, Mr. Leandro, what do you have, sir?
Good morning, Your Honor. Number 53 on your docket, it's a status.
Okay, CL 21-1222-I, Juan Duran Salcedo versus Jose Parra Acero, ACERO et al.
Yes, Your Honor. Eddie Leandro on behalf of defendants Jose Parra Acero and Jose Guadalupe Parra.
Good morning, Your Honor. Bill Garza, on behalf of defendant Salcedo.
Good morning, Judge. Edgar Garcia here on behalf of Maria Guadalupe Armijo, the plaintiff.
Okay, and what is the announcement, gentlemen?
Your Honor, with respect to the plaintiff Mercado, who has sued defendant Salcedo and both defendant Parras, that case has resolved. We have settled the case. We have Rule 11 agreements. We spoke with Mr. Zambrano on Friday. The only thing we are pending to get the case fully off the court's docket from that portion of the case is Mr. Zambrano is working with Medicaid to reduce the lien. And once we get that information, he'll provide us with drafting instructions and we can get the settlement checks issued for that portion of the case. Then there's the other portion, which is my client Salcedo, who I think is being represented by Ray Ortiz, has a lawsuit against the Parra defendants as well.
That's correct, Your Honor. As it relates to Ms. Mercado, my clients have also reached settlement, and we're also in the same boat that Mr. Garza is in. We're waiting for final drafting instructions. However, there is still a pending lawsuit between Mr. Ortiz's client, Mr. Duran Salcedo versus my client. So we have half of the case resolved. We're still working on, I think, depositions on the other part of the case.
Okay, so then, and there's not really a timeline as to how long it'll take Medicaid to give them that kind of information, right?
Correct.
I've heard it. Go ahead, Mr. Garcia.
Judge, I think that we will get drafted instructions to defense counsel within 30 days to resolve the hospital lien that's pending. We've
Okay.
been working to get that reduced, and it should be within 30 days. That is as far as plaintiff Mercado.
Okay, let me go ahead and just give you all a status hearing for September 26th, and that'll be plenty of time, and then we'll see where you are at that point.
Okay, and that'll be at 9:30 in the morning, Your Honor?
Yes. But I mean, who knows, you might be able to get everything done before then.
Correct.
Okay, anything else?
That is all I have, Your Honor. May I be excused?
Yes, sir.
Thank you.
That's all we have, Judge. Thank you. Good seeing you, and have a good day.
Likewise, sir. Thank you.
Yeah.
Mr. Garcia, anything else?
No, Your Honor. May I be excused?
Yes, sir.
Thank you.
Okay, Ms. Cantu del Bosque, what do you have, ma'am?
Good morning, Your Honor. I'm here on number 52.
CL 21-0590-I, US Bank versus Sary, S-A-R-Y Flores.
Yes, Your Honor. Good morning. Cynthia Cantu del Bosque on behalf of the defendant. I'm not sure if anyone is here for the plaintiff.
Ms. Cogan? It doesn't look like it.
Your Honor, no one appeared at the last setting either. I haven't had an opportunity to discuss this matter with the plaintiff's attorney or any of their representatives. I would ask that the court set this for a DWAP.
Okay. And let me see. What is in, I'm not sure, Ms. Iveta, are you on still?
Yes, Judge, it's August the 29th at 1:30, Your Honor.
Okay, August 29th at 1:30.
Thank you, Your Honor. That's all I have before this honorable court. May I be excused?
Yes, ma'am.
Thank you. Have a wonderful day.
Thank you, likewise. Okay, Mr. DeGroot, what do you have, sir?
I'm here on number 49 on the court docket, Your Honor, a status conference hearing. I represent the plaintiff, Domingo Galvan.
Okay, CL 21819-I, Domingo Galvan versus Farmers Insurance. And anyone here for the defense?
Yes, Your Honor. This is Allison Caselli for Farmers.
Good morning, Judge Frank Sabo for the Hacienda Ford Yoder Ford group of defendants.
Okay, and what is the announcement?
Your Honor, we're trying to set up a deposition for Mr. Galvan and also the service manager at Hacienda Ford. And I think due to there being 3 parties in the summer schedule, it looks like we're looking at August, I think, for the deposition schedule.
Okay, anything else to add, Mr. Caselli or Mr. Sabo?
Nope.
Oh, sorry. Yes, Your Honor. We also have a motion to sever that's on file, and it's set, I believe, for the 27th of August, and we're just waiting to get a Rule 11 to get that that hearing date passed.
Okay, so all of y'all are in agreement to pass that hearing?
Yes.
I believe so. We just haven't heard from Hacienda yet.
Okay, Mr. Sabo, have you had an opportunity to review that?
Judge, I'm actually standing in for someone else on this today, so I don't have any idea what's going on that.
Okay.
I will let him know to contact Ms. Caselli.
Okay, so then what we'll do is we'll let that hearing stand, and then if you get the Rule 11 agreement before then we'll go ahead and get that taken care of. Other than that, so depositions won't be until August, and then I guess we can come back on October the 3rd at 9:30.
October 3.
Okay, anything else?
That concludes my business, Your Honor. May be excused.
Yes, sir.
Thank you.
Judge, I've got a couple more.
Okay, Ms. Caselli?
That's it for me. May I be excused?
Yes.
Thank you.
Okay, Mr. Sabo, what do you have?
I also have number 42. And our announcement on that is we mediated on June 2nd and settled. So we're waiting
Okay.
drafting instructions. I think there's a lien that's slowing it down.
Let me go ahead and call the case, CL 185513-I, Vilma, VILMA, Vanessa Torres versus Fabiola Dominguez. So that case settled in June, and you're waiting for drafting instructions?
Correct.
Okay, then what I'll do is I'm just gonna set a tickler for that to see if you've submitted the documents. And I'm gonna set that for August the 5th. And that should hopefully be enough time.
I hope so, yeah.
Okay, your next case?
The next one is number 48.
CL 196725-I, Bernardo Treviño versus Eunice Marin et al.
Sorry, Your Honor. Heather Abreu on behalf of plaintiff.
And Rose Sandoval for Allstate.
Go ahead.
Judge, Heather and I agreed to a date for a mediation, and I didn't see that Rose was included on those emails, so I fear that she wasn't and might not know that we are set for mediation on August 17th at 4 o'clock with Mike Zanka. I hope she can make it.
Ms. Sandoval will be on vacation. I think that's what she's gonna announce. No, I'm just kidding. I don't know.
We just got brought into the case. I mean, I don't know if we'll be ready for mediation on August 17th for my part. I need to look at it.
Okay.
I don't even know that we had the plaintiff's medical records until perhaps last Friday. So.
Okay, well, I'll let you all try to figure that out, and we'll come back on October the 3rd and see if you have something fruitful to report at that time
Sounds good.
at 9:30.
Sounds good.
Okay,
Right.
anything else?
That's
No.
all I've got. I think that's all three of us have. Can we
Right.
all three be excused?
Yes, you may.
Thanks.
Bye.
Thank you. All right, Mr. Trevino, what do you have, sir? Mr. Trevino?
Good morning, Judge. I have
Good
number
morning.
56 on the docket. And Mr.
CL 212686-I, Jesus Alba ALBA versus Santos Transports.
That's correct, Judge. We're still conducting discovery. We're in the written discovery. Mr. Florencio Lopez is on the other side. Although he couldn't be here today, I did talk to him. We're hoping that maybe we can take care of this case in a couple of weeks.
As far, are you scheduled for mediation?
No, we're gonna try and conduct an informal mediation. I feel that, or we feel that we could probably settle this case.
Okay, then I'll give you a setting for September the 12th at 9:30. And then if you get it done before then, just let us know.
Thank you, Judge. May I be excused? I
Yes,
have no-
sir.
Thank you.
Okay, thank you. Mr. Hinojosa, what do you have?
Judge, number 35 on your docket.
Okay, that's F0069-22-9 in the matter of the marriage of Amy Nittler and Stephen Nittler.
Yes, Judge, it's my motion to enter the order. This case did mediate and was proved up. Mr. Stephen Nittler has not signed off on the decree, and we basically filed a motion to enter, Your Honor. It was proved up all issues at mediation. It was proved up before the court. Of course, I represent Amy Nittler, and we're just asking the court to sign off on the order, Judge.
Okay, I do recall that, and I did say that if for some reason you had some trouble getting the signatures, so I'll go ahead and your motion to enter is granted, and I'll ask for that to be forwarded to my queue.
Thank you, Judge. That's all I have before the court.
Okay, thank you, sir.
Thank you, ma'am.
All right, Judge Cantu, what do you have?
Good morning, Your Honor. I have number 44 on your docket. It's a status hearing with Spring Valley Produce, Inc. versus Clock by Green Transport, whom I represent.
CL 191562-I Spring Valley Produce versus Clock by Green Transport.
Yes. Your Honor, basically, I would request that we get a DCC or a trial date because I haven't been able to talk to Mr. Montalvo for one reason or the other, either my fault or his or, availability. So,
Okay. But has the discovery already been conducted?
yes, I believe so.
Okay, go ahead and file a motion for DCC, please,
Okay,
and we'll get you set up.
very well, Your Honor.
Okay, anything else?
No, that's all I have before this honorable court. May I be excused?
Yes, sir.
You
Thank
stay
you.
safe and have a happy holiday.
Likewise.
Thank you.
Thank you. Okay, Mr. Flores, what do you have, sir?
I have number 13 on your docket, Your Honor. This is an agreed divorce. All parties have signed off on it. Mr. Francisco Martinez is on the other side. I talked to him yesterday afternoon. He told me that he would not be able to attend since I believe his father is ill and he's in the hospital with him. But he signed off on it. His client signed off on it, Your Honor.
They called and unfortunately, Mr. Martinez's father passed away.
I'm sorry to hear that.
Yes, so that's F0097-22-9 in the matter of the marriage of Maria Luisa Hernandez and Agustin Hernandez. Is Mr. Hernandez also present?
I don't know.
Or are
but
we
my
just
client-
proving it up with your client?
Yes, Your Honor.
Okay, Maria Luisa Hernandez,
She's right there in the
Can you-
bottom.
can you hear me, Ms. Hernandez? Is she Spanish speaking?
No, yes, Your Honor, she's Spanish speaking.
Okay, Ms. Castaneda, can you please ask Ms. Hernandez to raise her right hand?
Ms. Hernández, por favor, levanta su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí, lo juro.
Yes, I swear.
Okay. And she can lower her hand?
¿Puede bajar su mano?
Mr. Flores, will you require Mr. Martinez's client to also be sworn in?
Yes, that will be good, Your Honor.
Is he Spanish speaking as well?
I think so. I'm not too sure.
Okay, Ms. Castaneda, can you please ask Mr. Agustin Hernandez to raise his right hand?
Agustín Hernández, por favor, levanta su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Okay. All right, Mr. Flores, go ahead.
Thank you. Please state your name for the record, ma'am.
Por favor, Miss María, por favor, diga su nombre.
María Luisa Santiago Hernández.
María Luisa Santiago Hernández.
Prior to the filing of this petition for divorce, were you a resident of the state of Texas and the county of Hidalgo for at least 6 months?
Antes de meter esta petición, usted era residente del condado de Hidalgo y del estado de Texas por los precedentes 6 meses.
Sí.
Yes.
You got married to Mr. Agustin Hernandez on or about October 29th, 1993.
Usted se casó con el señor Hernández como la fecha de octubre 29 del 1993.
Sí.
Yes.
And you separated on or about November 29th, 2021.
Y se separaron como el 29 de noviembre del 2021.
Sí.
Yes.
You're asking for divorce because your marriage has become insupportable due to conflict of personalities that destroys the legitimate ends of your marital relationship.
Y usted está pidiendo un divorcio porque se han vuelto insoportables y están es por insoportabilidad, ¿correcto?
Sí, correcto.
Yes, correct.
Do you think that you and Mr. Hernandez will never get back together?
¿Usted cree que usted y el señor Hernández se van a volver a juntar?
No.
No.
During this marriage, you had 2 children, Jonathan, born December 13th, 2006, and Alexandro, born October 15th, 2010.
Durante el matrimonio, ustedes tuvieron 2 hijos, Jonathan, nacido el 13 de diciembre del 2006, y Alexandro, nacido el 15 de octubre del 2010.
Sí.
Yes.
Both you and Mr. Hernandez have agreed that you will be both named joint manager conservators but you will have the exclusive right to designate the primary residence of the children.
Que han llegado a un acuerdo que los dos van a ser conservadores de gestión junta, pero usted va a tener el derecho de decidir dónde viven los niños, ¿correcto?
Sí, correcto.
Yes.
Mr. Hernandez will have the right to visit the children under the standard possession order of the Texas Family Code.
Y el señor Hernández va a tener derecho de visitar a los niños bajo la custodia del Texas Code, ¿correcto?
Correcto.
Correcto.
Child support is going to be set at $285 starting July 1st, 2022.
En la manutención se llegó de acuerdo que van a ser 285 comenzando en julio del 2022, ¿correcto?
Correcto.
Correct.
And after the oldest child either graduates from high school or turns 18, the child support will be reduced down to $228 per month.
Y después del que primer niño cumpla los 18, se va a rebajar a 228 por mes, ¿correcto?
Correcto.
Correct.
The children are under Medicaid, is that correct?
Los niños ahorita tienen Medicaid, ¿correcto?
Correcto.
Correct. Mr. Hernandez will have to be paying $57 to the state of Texas for coverage under Medicaid.
Y el señor Hernández va a estar pagando $57 para el estado de Texas para cubrir el Medicaid, ¿correcto?
Correcto.
Correct.
And in terms of property, there was no community property accumulated during the marriage other than personal effects. Is that right?
Okay. Tocante a propiedades, no hubo propiedades comunales que se acumularon hasta nada más lo que tienen sus cosas personales, ¿correcto?
Correcto.
Correct.
You're asking this court to award you whatever you have in your possession and to award Mr. Hernandez whatever he has in his possession.
Está usted pidiéndole a la corte que le otorgue a usted lo que usted tiene en su posición y que le otorgue al señor lo que él tiene en su posición, ¿correcto?
Correcto.
Correct.
In terms of debts, you keep whatever debt you incurred after the date of separation, and Mr. Hernandez can keep whatever debt he incurred after the date of separation.
Tocante a las deudas, usted se va a quedar con deudas que tiene después de la fecha de que se separaron y el señor Hernández también, ¿correcto?
Correcto.
Correct.
You're asking this court for divorce.
Y está usted pidiéndole a esta corte un divorcio, ¿correcto?
Correcto.
Correct.
That's all I have, Your Honor.
Okay. Do you have any questions of Mr. Hernandez?
Yes, just a couple, Your Honor.
Okay, Ms. Castaneda, please let Mr. Hernandez know that Mr. Flores just has a couple of questions for him.
Señor Hernández, el señor Flores tiene algunas preguntas para usted.
Mr. Hernandez, did you hear the testimony from your wife?
Señor Hernández, ¿usted oyó el testamento que dio su esposa?
Sí.
Yes.
Are you in agreement with everything that she said?
¿Y está usted de acuerdo con todo lo que se dijo?
Sí.
Yes.
In fact, you signed off on the decree of divorce, is that right?
Usted ya firmó el decreto, ¿correcto?
Sí.
Yes.
That's all I have, Your Honor.
Okay, then the court is taking judicial notice of all the documents in the court's file and is approving the agreement as testified to on the record. Did you state that your client wanted a name change?
No, Your Honor, she does not.
Okay. And so as soon as that is forwarded to my queue, because it's signed off by all of you, I'll sign off on it.
Okay, thank you, Judge.
Okay, Ms.
Yeah, we all
Castaneda, please, yes, and please let them know that they are excused.
Okay, Mr. Hernández y señor Hernández ya se pueden retirar.
Gracias.
Thank you.
Okay, just a reminder to the rest of the attorneys, if you have a quick announcement, please signify with your raise your hand reaction button. If you don't have your raise your hand reaction button and it doesn't take you to the top of my screen, then I'm going to assume you have a contested issue or something else is going on. But if there's a quick announcement, please signify with your raise your hand reaction button. All right, Ms. Alvarado, what do you have?
Good morning, Your Honor. I have a few announcements this morning. First, Judge number 1, I'm standing in for Mr. Hector Bustos. This is on your DWAP docket.
CL 152073-I Juan Jose Villarreal versus Lionel Garcia et al.
Your Honor, Mr. Bustos represents the plaintiff in this case. However, Mr. Bustos couldn't be present to make the announcement because he is starting a trial in the 93rd District Court. But he is requesting 30 days, Judge. They've requested business records affidavit for medical records, and they're still waiting on that. So that's the information I was given. So he's asking for 30 days.
I'm not even sure that the defendants have been served. But I'm not sure that you probably won't be privy to that information. We'll have a status hearing on this on September. We're gonna just hold over the DWAP to September the 12th.
Okay. I'll let
At
them know.
9:30, and that'll be in person.
Yes, Your Honor, I'll let them know. Now, Judge, I also have number 65 on your docket, and opposing counsel is Mr. Daniel Ramirez, who is also on the screen.
Okay, F4482-20-9, in the matter of the marriage of Jonathan Ho and Carla, Karla Ho. What are the announcements?
Yeah, Daniel Ramirez, representing Jonathan Ho, the petitioner, Your Honor.
And Catarina Alvarado for Mrs. Ho, the respondent in this case, Judge.
The good news, Judge, is that we went to mediation and we finally got this case settled.
Great. Are we ready to prove it up?
We're ready to prove it up, Your Honor, with Mr. Ho.
Okay.
Your Honor, just for the record, my client is not present. She is out of the country. I know Mr. Ramirez attempted to get a decree to me before today's hearing, but we weren't able to. But the mediated settlement agreement has been filed with the court, and Mr. Ho will be proving, Mr. Ramirez will be proving it up with Mr. Ho based on that mediated settlement agreement.
Okay, that's fine. Mr. Ho, will you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may lower your hand. Go ahead.
Thank you, Judge. Would you state your name, Mr. Ho?
Jonathan Ho.
And you're married to Karla Ho, that's Karla?
Yes.
You filed a divorce petition against her?
Yes.
Before you filed the divorce petition against her, you lived in Hidalgo County, Texas, for at least 3 months, and you lived in the state of Texas for at least 6 months?
Yes.
And you're requesting a divorce against your wife based on the ground that there is a discord or conflict of personalities between you and her that has destroyed the marriage relationship?
Correct. Yes.
Do you expect to reconcile yourself with your wife?
Yes.
You plan to get back together with your wife?
No.
You have 2 children, is that right?
Correct.
From the marriage?
Yes.
That would be Allegra Ho
Correct.
and Armandi Ho,
Correct.
and both are children under the age of 18?
Correct.
Did you and your wife adopt any children?
No.
To the best of your knowledge, is your wife expecting another child?
No.
You and your wife went to a mediation conference and settled the terms of your divorce case, is that correct?
Yes.
And as far as the children are concerned, both of you have agreed to be appointed joint managing conservators of the children, with your wife having the primary custody of the children, is that right?
Correct. Yes. Yes.
And your visitation, yes?
Yes.
Your visitation with the children will be in accordance with the new standard possession order, is that right?
Correct.
Right now, you have moved to Nevada, and that's where you are right now, is that correct?
Yes, correct.
And one of the agreements regarding visitation is that any travel expenses are going to be paid by you 100%?
Correct.
There's also an agreement on the telephone and electronic access with the children, and that would be that the party not in possession of the children can have telephone access to the children, between the hours of 7 and 8 p.m. Central Time, and the children can call at any time. Is that correct?
Correct.
As far as child support, you've agreed that you are going to be paying child support of $800 starting July 1, 2020.
Correct.
And there's going to be
I'm sorry, Mr. Ramirez, was that 20, you said 2020, but did you mean 2022?
That's what I mean, Judge.
Okay.
And there's going to be a step down after the first child no longer is qualified to receive child support. Is that correct?
Correct.
And as far as any retroactive child support, there's not going to be any retroactive child support, but there was a provision that you agreed to. I think you had sent in $500 child support for the month of June 2022. And at the time of the mediation, Mrs. Ho says she had not received it. So the agreement is if the check got lost in the mail, then you'll owe $500 and there'll be a judgment for that amount. Is that right?
Correct, but she already received in cash already.
Okay. All right. Well, then there would be no retroactive child support if those are the facts. Would that be correct?
Yes.
As far as medical support, you're going to be providing for the medical support for the children, and you're going to be providing proof to your wife within 15 days of the coverage. Is that right?
Correct.
And you understand that if you do not get the medical support for the children, then you will owe 100% of the medical expenses. Is that right?
Correct. Yes.
And you also understand that any medical expenses that are not covered by insurance will need to be paid on a 50-50 basis by you and your wife. Is that right?
Correct.
In the community estate, you have two pieces of realty. One is a condominium located at 3003 South L Lane, Apartment C, McAllen, Texas. Is that right?
Correct.
And you've agreed that your wife will keep that piece of property as her separate property.
Correct.
Is that right?
Correct.
The second piece of realty is a vacant lot. It's located at 4713 Sweetwater Avenue, McAllen, Texas. Is that right?
Correct.
And the agreement is that that lot is to be listed for sale within 30 days from the signing of the mediation settlement agreement. Is that right?
Correct.
From the net sale proceeds, your wife is going to be keeping $15,000 and you're going to be keeping the balance of the money from the net sale proceeds. Is that right?
Yes.
And both parties are going to be signing any necessary documents for the sale of the property. Is that right?
Yes.
Unless paid and standard by the mortgage company to your wife. Let me rephrase that. Unless the $15,000 is paid in standard by the mortgage company to your wife is going to be paid those $15,000 within 48 hours of the funding of the sale. Is that correct?
Yes.
As for vehicles, you're going to be keeping your 2015 Pathfinder and any debt associated with it.
Yes.
And your wife is going to be keeping the 2021 BMW 3301 and any debt. Is that right?
Yes.
As far as debts, each party is going to be keeping any debt under their sole names after the date of separation, which was in September 2020. Is that right?
Yes,
You had a business with your wife. It was the nail spa business. And regarding that business, you're going to be keeping 100% of the PPP business loan liability. Is that right?
yes,
And you're going to be also keeping 100% of the promissory note liability to your family. Is that right?
yes,
You're going to be releasing any claim against your wife for the loss of business, of the business when the business was not sold. Is that right?
yes,
And your wife is going to release her claim against you for abandonment. Is that right?
yes,
With the exception of the PPP business loan liability, both you and your wife will be dividing any business debt of the nail spa business on a 50-50 basis. Is that right?
yes,
And both you and your wife will be signing an affidavit that no additional business debts were taken out after the May 1st, 2021 date for the nail spa business. Is that right?
yes,
As for income tax returns, it's agreed that both parties will file jointly the federal income tax returns for 2020 and 2021 before October 15th, 2022, with the tax preparer Caridad Diaz. Is that right?
yes,
And both of you have agreed to comply with the required document disclosures and/or exchange any documents necessary for the preparation of those 2 years of federal income tax returns. Is that correct?
correct,
And any asset or liability associated with the 2020 and the 2021 years will be divided equally. Is that correct?
yes,
Yeah, and we're looking at dividing equally for the years of 2020 and 2021.
correct,
And the 2022 federal income tax return is going to be filed separately by each party. Is that correct?
correct, correct,
And you're asking for a divorce, Mr. Ho?
yes.
I'll pass a witness, please.
Okay, any questions, Ms. Alvarado?
No, Judge, I don't have any questions of Mr. Ho.
Okay, so is that your understanding of the agreement on behalf of your client?
It is, Your Honor.
Okay, then the court is taking judicial notice of all the documents in the court's file, specifically the mediated settlement agreement that has been filed and executed by all the parties. And how much time do y'all need to submit the divorce decree?
Judge, we've been working on the divorce decree, maybe another 2 weeks, Your Honor, at the very least.
Okay, let me go ahead and put, well, Ms. Alvarado, does your client have access to retrieve the decree to sign off on it?
She does, Your Honor, but she'll be back in the country on July 4th. So if we could have
maybe 2 weeks from July 4th, Judge.
Okay,
Well, Judge,
that's fine.
I'd like it sooner than later since this was done June 8th. So if we could have it just 2 weeks from today, a deadline.
I'll put a tickler for July the 15th.
Very well.
Okay, anything else?
Judge, Mr. Ramirez and I also have number 14 on your docket.
Okay, Mr. Ho, we'll go ahead and that concludes your case. And then as soon as everyone signs off, then I'm sure you'll receive a copy of your divorce decree, okay?
Thank you.
So your divorce is granted, and as the agreement that you testified to on the record as well. So this concludes your part. Your attorney has other business here, okay?
Okay, thank you. Yeah.
Thank you. Best of luck.
Yeah.
All right, what number?
Number 14, Your Honor.
F0453-21-9 in the matter of the marriage of Nayeli, Nayeli Faisal, Faisal versus Luis Faisal.
Yes, Judge. I believe both parties are online.
Okay, Mr. Faisal, Ms. Faisal, can you hear me?
I can hear you.
Okay, Mr. Faisal, can you hear me?
Yes, I can hear you.
Okay, and is this ready to be proved up?
Yes, ma'am. This was also mediated and settled.
Okay, can I please have,
Excuse me, Judge. I
Judge, we
misspoke.
don't have a mediated settlement agreement of this. We attended
It's
mediation.
just an agreement.
Yeah, it's just an agreement of the parties.
okay, so if I can have both of you raise your right hand, please. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Ms. Faisal, yes or no?
Yes.
And Mr. Faisal, yes or no?
Yes.
All right, you may lower your hands. And who will be proving up the agreement?
I will, Judge. Daniel Ramirez representing Nayeli Faisal.
Okay, go ahead.
Thank you. Ms. Faisal, would you state your name?
Nayeli Faisal?
You live in Hidalgo County, Texas,
Yes.
and you're married to Luis Javier Faisal.
Yes.
You filed a divorce petition against him.
Yes.
Prior to filing the divorce petition, did you live in Hidalgo County, Texas for at least 3 months and in the state of Texas for at least 6 months?
Yes.
And you're asking the court for a divorce on the ground that there's been a discord or conflict of personalities between you and your husband that has destroyed the marriage relationship. Is that right?
Yes.
Do you expect to reconcile with your husband?
No.
From the marriage, you have 2 children, Genesis Saida Faisal and Itzel, Itzel Nayeli Faisal. Is that correct?
Yes.
And they're both minor children?
Yes.
Did you and your husband adopt any children?
No.
Are you expecting a child at this time?
No.
Both you and your husband have agreed that both of you be appointed joint managing conservators, with you having the primary custody of the children?
Yes.
And as far as visitation, your husband is going to be visiting with the children under the new standard possession order. Is that correct?
Yes.
The child support that you've agreed to is $705 per month starting June 1st, 2021. Is that right?
Yes.
And the step down is going to be $564.
Yes.
In other words, after your first child no longer qualifies, then your husband would be paying $564. Is that right?
Yes.
As far as medical support, you're providing the health insurance, the dental, and the vision. For the health care, you're providing a policy that the premium is $279.82 per month. The dental is $68.81 per month, and the vision is $6.71 per month. Is that right?
Yes.
And the agreement is that your husband's going to be reimbursing you for these amounts starting June 1st, 2022?
Yes.
And you understand that any expenses that are not covered by insurance, both you and your husband will be paying 50% of that. Is that correct?
Yes.
There's also going to be a geographical restriction where your children need to reside in the Rio Grande Valley, consisting of the Hidalgo County, Texas, Cameron County, Stark County, and Willacy County. Is that correct?
Yes.
And as far as passports, you're going to be applying for the passport and you're going to be having the sole authority to do so. Is that correct?
Yes.
As far as the telephone and electronic communication with the children, both you and your husband will be able to talk to the children at 6:30 p.m. to 8:30 p.m. each day of the week, when either one of you does not have the children in their possession. Is that correct?
Yes.
And your children can call either one of you at any time they want. Is that right?
Yes.
As far as the division of the community estate, what you're going to be getting as your sole and separate property is a house and lot located at 4917 Ibis Avenue. That's IBIS Avenue, McAllen, Texas.
Yes.
And you're going to be keeping any household furniture, furnishings, other items, including the items in the house located at 4917 Ibis Avenue in McAllen, Texas. Is that right?
Yes.
You're going to be keeping any clothing, jewelry, other personal effects, any sums of cash in your hand or in banks under your name. Your retirement plan with the Sharyland Independent School District, which would be the TRS plan. Is that correct?
Yes.
And you're going to be keeping the 2019 Honda CRV vehicle. Is that right?
Yes.
Your husband is going to be keeping as a separate property any household furniture and other personal items that are in his possession. Is that right?
Yes.
He's going to be keeping any clothing, any cash he may have in hand or in banks under his name. And the retirement plan that he has with the employer, South Texas College, it would also be through the Teachers Retirement System of Texas, TRS. Is that correct?
Yes.
He's going to be keeping the 2017 Nissan Sentra. Is that right?
Yes.
Now, you're going to be keeping the house, but also you're going to be paying your husband the lump sum of $22,000 for his share of the equity in the house. And this is a house located at 4917 Ibis Avenue in McAllen, Texas. Is that right?
Yes.
And he's going to be providing you with a special warranty deed to that house, which would transfer his interest in the house to you. Is that right?
Yes.
Mr. Ramirez, I believe it was agreed to that he will be signing a special warranty deed as when provided to him regarding that home.
Thank you for the clarification. Okay. As far as debts, you're going to be paying any debts that you incurred under your name after the date of separation. You're going to be paying 100% of the mortgage debt on the house and lot located at 4017 Ibis Avenue in McAllen, Texas, and 100% of the personal loan of $4,000 that is owed to your parents. Is that right?
Yes.
And your husband's going to be paying any personal debts, any debts that he has under his sole name after the date of separation, and also the debt on the Capital One credit account under his name. Is that right?
Yes.
You're also requesting that the court change your name to Nayeli Martinez, Nayeli Martinez. Is that correct?
Yes.
And you're asking the court for a divorce?
Yes.
That's all I have. Pass the witness, Judge.
Okay. Ms. Alvarado, any questions?
Yes, Judge, just a couple of clarifications with my client. Mr. Faisal, you heard the questions and the responses asked and answered by Mr. Ramirez and your wife, Nayeli Faisal, is that correct?
Yes.
And you're in agreement with everything that was said regarding the children and the property division?
Yes.
And now, Judge, just for clarification, regarding the passports, Mr. Faisal, it was agreed to that your wife would be able to request the passports and hold them. However, we further agreed that if you need the passports for travel with your daughters, Ms. Faisal is required to turn them over to you within 24 hours. And upon your return from travel, you will return them to her. Is that correct?
Yes.
Okay. And are you asking the court for a divorce?
Yes.
That's all I have, Your Honor.
Judge, there is, regarding the passports, Judge, there is one more item. If I may reopen with my client just briefly.
Okay, go ahead.
Ms. Faisal, there's an agreement that each party will pay 1/2 the total cost of the passports.
Yes.
All right. That's all I have, and I have just a question for Mr. Faisal, Judge.
Go ahead.
Mr. Faisal, what is your current address right now? We need to put that in the divorce decree.
My current address is 2512 Hibiscus Avenue, apartment 1, McAllen, Texas, 78501.
Let me repeat that. You said 25, and I didn't hear the last number.
2512 Hibiscus Avenue, apartment 1, McAllen, Texas, 78501.
Thank you, Mr. Faisal. That's all I have.
Okay. If nothing further, then the court is taking judicial notice of all the documents in the court's file and granting the relief as requested and testified to on the record by both parties. And also your divorce decree, can you have it in by the same 15th, on July 15th?
Yes, ma'am.
Okay, we'll set a tickler for July 15th as well then.
Okay. Thank you, Your Honor.
Okay, anything else?
No, ma'am.
This concludes my business, Judge. May I be excused?
Yes, you both may be excused.
Thank you.
All right, thank you. Best of luck to you, Mr. Faisal and Ms. Faisal.
Thank you.
Thank you. All right, Mr. Salinas, what do you have, sir?
Good morning, Judge. I believe it's number 11 on your docket.
Okay, F2405-19-9 in the matter of the marriage of Hector Garcia and Cassandra, Kassandra Garcia.
Yes, Your Honor. Judge, I received a call from Mr. Morales's office that somebody in his family was ill. I believe his significant other was ill and he was not making it to work today. Asked if we could ask the court for a continuance. We have no problems with that. There is a prior case, Judge. It's a suit affecting the parent-child relationship where there's a prior court order, and I believe it's out of the 92nd District Court. And I'm not sure if Mr. Morales had a chance to look at it, but we filed a motion to transfer this case from your court to the court of original jurisdiction so we could resolve all the issues.
Okay, so this was set for DWAP today. So when was that filed for it to transfer over to the original court?
Sometime last week, Judge.
Okay, well, I'm going to grant that and I'll go ahead and ask my staff to look for it so that we can sign off and you all can keep it going in the 93rd.
Thank you, Your Honor. Appreciate that. That's all I have, Judge.
Go ahead, Ms. Rivera.
Judge, can I have the cause number? I don't believe that there's the motion to consolidate into the 92nd. It may have been filed in the 92nd case rather than ours.
I think it's the 93rd.
92nd, Judge, I believe.
Oh, 92nd, okay. And what is the cause number?
I don't have that cause number, Judge. Only yours. So I'm sorry.
I don't see any motion or order on file regarding that, Judge, on our case.
Okay, if you can file a motion to consolidate or motion to get that transferred over to the 92nd, let us know, file it into this case.
Yes,
And
Judge.
please get that done by July the 15th.
Okay, Judge, we'll do that.
Okay, anything else?
That's all we have, Judge.
All right, thank you.
Thank you.
Okay, Mr. Dawson, what do you have?
Good morning, Judge. I believe I'm number 16 on your docket.
Okay, that's F 3025-20-9 in the matter of the marriage of Marcia Marsha Padilla and Kenneth Dawson.
Kenneth, but yes, Your Honor, that is
Kenneth,
correct.
okay.
And I do believe that the petitioner, Ms. Marcia Padilla, is present.
Okay, Ms. Padilla, have y'all reached an agreement in this matter?
Yes, Judge.
Okay, do you all have a prior case open with the Office of the Attorney General?
Yes, yes, Your Honor.
Okay, how long has that case been open?
That case was opened, I believe, back in at the same time as this case has been in August of 2020.
Okay, and do y'all have, did they give you a separate case number or an OAG number?
No, Your Honor, they were just involved due to the temporary orders. We actually don't have any type of child support case or anything like that. No hearings.
Okay, so did they ever file an order? Do you all have an order from that Office of the Attorney General where they started taking out money for child support?
Well, no, Your Honor, what happened was due to the temporary orders, I had established voluntarily child support, and we've just been acting on the temporary orders since then.
Okay, but when you say temporary orders, is there something in written form?
There are written temporary orders from the County Court 5, Your Honor.
Okay, then that's the court where you all are supposed to have this case in court 5.
Well, that court was transferred, Your Honor. This is now the jurisdiction of this case. It was transferred.
So court 5 transferred you to this case, to this court?
Yes, ma'am.
Okay, let me have, Ms. Rivera, can you look that up? Because I do not have access to my Odyssey right now.
Judge, on this case, this was the case that Ms. Lucy Williamson and Abel Hinojosa were both retained on, Your Honor. Then they withdrew back earlier this year, Your Honor, and there was, these parties proceeded to be pro se. There was a transfer done from court 5 to court 9. I'm trying to find the actual temporary orders, Your Honor.
But there isn't any, there's the state has not filed an intervention then.
From what I can see, Your Honor, no. And I just found the temporary orders, Your Honor. They were filed and, well, Judge Arnold signed them September the 23rd, 2020.
Okay. So now that you all are proceeding on your own, have you all entered into an agreement?
Yes, Your Honor. We not only entered into agreement, but we've also submitted our finalized decree to the court.
Okay,
and have,
and you both have signed off on it?
Yes, Your Honor.
Okay, Ms. Padilla, have you signed off on it?
Yes.
Okay, then I'm going to review that, but for now, I need both of you to raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? Ms. Padilla, yes or no?
Yes.
Mr. Dawson, yes or no?
Yes, Your Honor.
Okay, you may lower your hands. Ms. Padilla, at the time that you filed for divorce, were you a resident of Hidalgo County for at least 90 days and of Texas for at least 6 months?
Yes.
And are you filing for divorce today because of irreconcilable differences?
Yes.
And are you and Mr. Dawson going to reconcile at this time?
No.
Okay. And you and Mr. Dawson have how many children?
1.
And what is the child's name?
Malaysia Ray Dawson.
And have you and Mr. Dawson entered into an agreement as far as child support and visitation?
Yes.
And how much will child support be?
For that, we discussed that there will be no child support.
And why will there be no child support? Is it because you can't just say no child support? Is your daughter on Medicaid?
No.
Okay, so who's providing health insurance for your child?
Her father.
Okay, so Mr. Dawson is providing private health insurance for her? Ms. Padilla, is Mr. Dawson providing private health insurance for your daughter?
It's not private health insurance, it's TRICARE.
Okay, so but there is health insurance for the child?
Yes.
Okay, so then, and as to child support, why is child support at 0?
We just feel that's something that's not necessary between us. We both provide for her equally.
Okay. The only reason that I'm going to approve that is because she is not on state assistance for medical insurance. However, when the child is in each of your possessions, you are financially responsible for your daughter. And do you all know how you're buying clothes and all of that for her?
Yes.
Okay. And so then are you asking for any child support that he has been paying is now what, terminated?
Correct.
Okay. Hold on. Okay. So is there any arrears that have been shown on this account by the Office of the Attorney General? Ms. Padilla, are there any arrears against Mr. Dawson at this time shown by the Office of the Attorney General?
No.
Okay. All right. And what about, do you all have any community property together?
It's the home that he's living in at this moment.
Okay, so you all purchased that home together?
No, we did not purchase it together.
Okay, so that's what community property is. So do you all have any community property that you all accumulated together?
No.
Okay, do you all have any debts together?
No.
So each of you will be responsible for any debts that are in your name?
Yes.
And what about vehicles?
No vehicles.
Hold on. Okay. And so is that all of your assets? So you all don't have any assets together, in other words?
Correct.
Okay. Mr. Dawson, is that your understanding of the agreement as well?
Yes, Your Honor. That is my understanding of the agreement. However, I just sorry.
Hold on. The lot that was purchased in FAR, is that under your name alone?
No, Your Honor. That lot actually has both our names on the deed. However, per our agreement, Ms. Padilla has forfeited her interest into that lot, and since I did purchase it before our marriage, it'll be considered separate property in my name.
So you purchased that property before your marriage?
Yes, ma'am.
So what's the $2,382? Are you paying that to her?
No, ma'am. That would be Ms. Padilla paying that to me, based on the fact that We did have, there was a vehicle that was purchased while we were married. And we made an agreement that only 10% of the value of that vehicle would be returned back to me.
Okay, I'm not, why are you making her pay 10% of that? I mean, you're not even paying child support. And she's,
Well, the reason, Your Honor, is because that purchase was made without my knowledge or understanding. I didn't even know that it existed until she filed for divorce. So the fact that the funds that were used to pay for this vehicle was taken out of the marital estate, we just agreed that she would pay back the 10% instead of half of the vehicle's value.
and that's your understanding of the agreement, Ms. Padilla?
Yes,
And is that regarding the 2019 Ford Focus?
yes,
And whose name is that under?
my name.
Okay. So that vehicle is under your name, but Mr. Dawson is claiming that you used some of the money that was in your joint account to purchase it, or what?
No, because we never had a joint account.
So where does the $2,382 come from?
Your Honor, even though our accounts were not joint, the fact that we had a marital estate, our two separate accounts made up our marital estate.
Okay, but that money wasn't even in your account. So how do you know that was your money and not her money?
Well, due to our marriage, that's how our budget worked. I made the majority of the money. So the fact that this vehicle was purchased using the majority of my money without my knowledge. I made a payment in order for her to correct her her credit. I made a payment towards her student loan in that amount, actually. And
Okay.
that's why it's being returned back to me.
Yeah, well, yeah, I'd like to see somebody else use that because they made the majority of the money type of thing over here and see how
Your
their
Honor.
spouse felt by that. Look, I'm not in agreement with the way that you all are splitting this up, but it's up to you all. Because obviously you all had very good attorneys and you both decided to fire them. And now Ms. Padilla has placed herself in a position, in my opinion, where she's getting the short end of the stick. But if that's what she wants, then that's fine. And Mr. Dawson, it's easy to see what position you played in your relationship. And so if you all want this divorce to go forward today, because I think this is like the fourth time that you all are in front of me, then that's fine. And Ms. Padilla, is that your testimony that you're going to want this divorce as to the terms that you have filed with this court already? Because you all have a divorce decree on file that you signed off on. So are you asking me to approve that agreement as you've testified to already and that is on file with the court? Ms. Padilla, I need an answer.
Yes,
All right. And Mr. Dawson, obviously you're in agreement with this, so I'm granting the divorce today and honestly against my better judgment, but that's your marriage, the way you've decided to do it, and you all are pro se, so now you all to assume that risk. So I'll go ahead and sign off on your divorce decree, and I hope you know, Ms. Padilla, what it is that you got yourself into. So anyway, if nothing further, you all are dismissed. Mr. Moreno, what do you have?
Thank you, Your Honor.
I'm sorry, number 37 on your docket. This is a
Okay.
status hearing. We have,
Let me go ahead and call the case. CO 151106-I, Lorden Gonzalez and Ignacio Perez and Ms. Kirkland.
See that.
Go ahead.
Mr. Perez and Elsa Perez were both,
I see Mr. Perez is on.
Good morning, Judge. Rick Godinez. I represent Mr. Perez only.
Okay. And Ms. Kirkle?
I'm here as well, Judge.
Oh, there you are. Okay.
Thank you, Your Honor.
All right. And what is the announcement?
Your Honor, the purpose of this hearing was to give Ms. Merkel time to get an attorney to represent her. This is like the third time that we're here on that same purpose.
Okay, so did you end up finding somebody, Ms. Perkle?
I did not, Judge. I am here in the Valley. I made it from California.
Okay.
I did have some appointments to accompany my father to Mr. Godinez's office. Like he said, he represents my father only at this time. I did want to consult with him about representing me, but we haven't been able to meet. The meeting's been pushed back a few times in the past 3 weeks that I've been here. So at this time, I do not have representation, but I understand what needs to be done to move forward. I will continue now that I'm here. I do have the additional documentation that I needed. I just need to talk to somebody, like I said, but I am willing to stay here and try to get that taken care of, Judge.
Okay, so then we're going to be proceeding with the case now.
Your Honor, should I go ahead and file a DCC, motion for DCC?
Well, if everything's already ready, I mean, it's a really old case. So yes, I would file your motion for DCC and so that way you can go ahead and is this going to be a jury trial or is it a bench trial?
We haven't asked for a jury.
I'll need to discuss that with my client's judge. There's a sister case associated with this, my client, and by the way, I'm not opposed to visiting with the pro se defendant to determine if there is no conflict or the parties are willing to sign conflict waivers. This one case is a little bit unusual because I have my client is elderly. In the one case, the sister case, he has owed money. In this case, the allegation is he needs to pay money. And so I think with the sister case that I'm trying to get resolved, we may be able to resolve this case, but without it, I just don't see any resolution other than a judgment on a piece of paper someday.
Okay, so then just go ahead then, Mr. Moreno, and file your motion for DCC and we'll get you set and that way we can move forward with it. And that'll give you the deadlines.
Okay, I'll get that done this week.
Okay, anything else?
No,
that's all I have, Judge. You have a great day.
Okay, likewise. Thank you.
Thank you so much, Your Honor. And on behalf of my father, I have him muted because our microphones are playing off each other, but he also thanks you.
Okay, thank you, ma'am. Y'all have a good day.
Yes, ma'am. Bye-bye.
Okay, now is it Miss Vanek or how do you pronounce your last name?
Yes, Your Honor, it's Vanek.
Okay, and what case?
I'm here on number 40, status conference.
Okay, CL 171964-I, LexisNexis versus Law Office of Roberto Flores.
Yes, Your Honor, I'm Brittany Vanek. I'm here on behalf of the plaintiff, LexisNexis. I don't know if anyone is here for defendant.
Okay, is anyone here for Mr. Flores' office? Okay, and how are you all going to proceed, Ms. Vanek?
Your Honor, the parties reached a settlement in this case several months ago, but the plaintiff, we haven't received the payment from the defendant. So we filed a motion to enforce the settlement agreement that we pulled down after the defendant told us that he had sent payment, but we still haven't received it. So we anticipate that if we don't receive that payment soon, we may have to file another motion to enforce the parties' settlement agreement.
Okay, so then was that settlement agreement filed in this case?
It was, and I just became involved in this case, so I don't have the date, but I believe it was around the beginning of this year.
Okay, because I wonder why then it stayed on my docket then. Let me see. Ms. Rivera, are you showing that there was disposition of this case?
Give me 1 second, Judge. There is a motion, Judge, and there was an order setting hearing on the plaintiff's motion, and that was set on the 24th of this year. However, I believe, Judge, that that was around the time that the court, our staff had been hit with COVID and those dockets had been reset. They had to file the order resetting, and I don't believe that they ever did, Your Honor.
No, but was there a settlement agreement that was filed in this?
Oh, as far as the settlement agreement, Judge, I don't believe that, no, Judge, it was just the motion to enforce.
Okay, can you please check, Ms. Vanek, that your settlement agreement is on file with us?
Yes, I can check on that.
And then if you need to reset your motion for enforcement, go ahead and do that. I'm just gonna set a tickler for the 15th. For July 15th to see about the settlement agreement.
Okay, thank you, Your Honor.
Okay, anything else?
That's all. May I be dismissed?
Yes.
Thank you, Your Honor.
Okay, Mr. Hernandez?
Good morning, Your Honor. I'm here on number 59.
Okay, good morning. F0727-22-9 in the matter of the marriage of Aaron Gracia and Stephanie Browen, Browen.
That is correct, Your Honor. Jaime Hernandez here on behalf of Stephanie Bruin. Your Honor, on this case, actually, Mr. Juan Ramos is the opposing counsel on this case. He did message me this morning. He's in person in the 332nd.
Okay,
And
he's on Zoom. Go ahead.
Oh, he's on? Perfect. Your Honor, our announcement on this is we've reached an agreement as to this case. Mr. Ramos has already submitted a proposed final decree to me. My client has reviewed it. I don't believe there are any corrections to be made. So as soon as we get that approved by both parties, we'll go ahead and e-file that.
Okay, so are any of your clients on so that you can prove up the agreement on the record?
Your Honor, my client is not on. I don't know if Mr. Ramos's client is on.
Mr. Ramos, is your client, Mr. Gracia, on?
Your Honor, I apologize. Can you hear me?
Yes.
Oh, perfect. I was transitioning in my car. I do not see my client here, Judge. When I was walking in my truck, I was browsing through, but I don't believe he's logged on either.
Okay, do they have children?
Yes, they do, Judge.
Okay,
One child, Your Honor.
so then now you're going to have to, we'll file your order setting final hearing then, and then we'll try to squeeze you in. So I don't know how fast you all are gonna get that done.
Understood. Is there any possibility to get that filed with the statement of facts or statement of evidence?
No, those I do, that's gonna be in person. Now it's gonna be today's my last Zoom civil, and you
Okay.
can tell why. And
Yeah.
so, now we finally already, I think, gotten everything transitioned over to in person. So I don't know, do we have a setting and go ahead and file your order setting final hearing? And I'll try to get you in the soonest July setting.
Okay, perfect. We'll go ahead and do that, Your Honor.
We'll do that, Judge.
Okay? So I'm gonna give you only until the 15th to file that order setting final hearing.
Understood. I'll get that filed today.
Okay, anything else?
That's it, Your Honor. That's all we have before this honorable court. May we both be excused?
Yes, thank you.
Thank you.
Okay, well,
Your
Mr.
Honor-
Ramos, you have one more.
Oh,
Yes, Your Honor, I apologize. I have number 63 on your docket. It's a
Yes.
status setting.
F3836-21-9 in the matter of the marriage of Ileana Iliana Hernandez versus Isidro Zamora.
Yes, Your Honor. Juan Ramos here on behalf of Miss Ileana Hernandez. Judge, we're trying to work with the opposing party. He's still pro se, but due to his lack of communication, I'm likely just going to go ahead and file a motion for default hearing. By way of background, he's just a little difficult to reach because he works continuously out of town. But we do have a means to serve him personally with notice once we get that court date, Judge.
Okay, so go ahead and get that filed before July the 15th so that we can get you on the docket.
Will do, Your Honor.
Okay, anything else?
I have nothing further, Judge. May I also be excused?
Yes.
Thank you, Your Honor. Take care.
Okay, thank you. All right, Mr. Pettis?
Good morning, Your Honor.
Okay,
I'm here on.
yes, sir.
I'm here on number 20, I believe. It's a friendly suit.
CL 220257-I, Brenda Evangelina Valle Sandoval and Noe versus Noe Cifuentes et al.
Yes, Judge, and I'm hearing.
Yes, Your Honor.
Okay, and I saw Ms. Flores logged in.
This is Cindy Garcia on behalf of the defendants.
Okay, and is Attorney Vanessa Flores still present? Okay, she is not present. Let me see if someone from my staff can contact her.
Okay.
And so she was logged on.
Okay.
So as soon as she gets back on, I'll recall you.
Thank you, Your Honor.
Thank you. Okay, Judge Hinojosa, what do you have, sir?
Good morning, Your Honor.
Good morning.
I just had a status conference on the Vargas versus Vargas divorce. It's 3648-13-9. It's an old case. And you had reset it to see whether or not the opposing counsel or whether Maria Guadalupe Vargas was going to show up. And I don't know that we've had anybody come into this case. So it would just be me representing Mr. Vargas. He's working somewhere up north, so I need to get a date by which we can just come in and approve the final divorce, Your Honor. So
Okay, that's number 62 on the court's docket, F3648-13-9. Alberto Vargas versus Maria Guadalupe Vargas. Is Maria Guadalupe Vargas present? Okay. Go ahead and get with your client for his schedule so that we can go ahead and get you
Yes.
set up. And if you want to set
all right,
an
Your
order
Honor. I'll
setting-
find out when.
if you want to file an order setting final hearing, that way we can go ahead and do that.
That's fine, Your Honor. I'll prepare something.
Okay.
Thank you.
All right. Thank you, sir.
All right, may I be excused? Thank you.
Yes, sir.
Thank you.
Thank you.
Bye.
Okay, Mr. Villalobos, what do you have?
Good morning, Your Honor. I got number 15 on the docket, Your Honor.
Okay, F1515-20-9 in the matter of the marriage of Oneida Juliana Hernandez and Ruben Hugo Hernandez Flores.
Judge, Ms. Oneida, Ms. Hernandez was on Zoom, but she had to get back to work. Judge, I'm asking for a 1-month reset because we're trying to serve him by publication, but she couldn't come up with the funds. But I understand he's back in town, so we're going to be able to serve him now. And I'd ask that this court could reset it for a month so we can close it out.
Okay, what is the earliest? It wouldn't be until August.
Whatever the court has, Your Honor, whatever's earliest for the court.
Okay, Ms. Rivera, what's the August setting?
Judge, we can squeeze them in on August 17th, Your Honor.
Okay, it would be August 17th at 9:30.
Thank you, Your Honor. I'm sure that'll be in person. We'll close it out then, Judge. We'll perfect service by then.
Yes, that'll be in person.
Thank you so much, Your Honor.
Okay,
You have a
thank
great
you.
weekend.
All right, thank you, you too. Okay, Mr. Khan, what do you have, sir?
Good morning, Your Honor. Attorney Howard Khan. I am here on a default on number 24 on your docket.
Okay, that's CL 201496-I McAllen Nursing Center versus Henry Leo.
Yes, ma'am.
Okay,
If motion for default, you granted our motion for substituted service some time ago. We effected service by sending it restricted mail as you ordered. And that's on record. This gentleman is over 69 years old. He's not in the military. We have filed all the appropriate paperwork for our default judgment. So we ask that you grant it. And also, I did notice earlier this hearing on 6/6, and I filed copies of the green card showing that I've actually served them notice of the hearing for today. And unless, I ask that you call them out and see if Ms. Duarte or Mr. Leo is present to see if we can, if they can avoid the default.
okay. Henry Leo? Henry Leo?
Yes, I'm here as his daughter. I have authority. I forgot what it's called. Sorry. I was here at the nursing home so I can have him on there, but he's not all there. He had the stroke. So
Okay, so do you have a power of attorney?
yes.
Okay, so you'll need to submit that to Mr. Khan so that he can speak to you about it.
And since I've not received a written response, so if she wants to file an answer, that's okay too. I know appearing at a default hearing may not technically be avoid a default, but no, we'll respect that. But she has to file an answer. If you could order her to file an answer and send me a copy of that POA, I'd appreciate it, Your Honor.
Okay, so Miss, is it Antolin?
Antolin.
Antolin, okay. Do you have something to write with?
To write with, I'm in my car, so I have to write something.
Well, you're going to need the contact information for Mr. Khan.
Oh, okay. Yes, let me.
It is on my paperwork, Your Honor, so it's in your order.
Okay, I got this from my brother. I didn't get a lot of information. So it's in that court order letter. That's the only thing I saw. Is that what you're saying? Is your contact information on that?
Yes, yes, and I'm easily found on the internet by just typing my name.
Okay.
Easy.
Okay, then we have it.
I'm not hiding because I want more business. Okay.
Okay.
But,
Okay,
yeah.
so Miss Antolin, go ahead and submit your power of attorney over to Mr. Khan. And then will you be representing yourself?
Yes. Yeah, so I'm barely learning about this. So I have to go and look into it. So yes, I'll be representing my brother as well. Does my brother need to also submit his power of attorney? Because it's me and him.
Okay, so the thing is it would depend how your power of attorney is written. Is it he only serves if you're unavailable? Who's first?
My brother's first.
Okay, then it would be your brother because you would only serve if your brother's unavailable, correct?
Yes.
Okay. If that's the case, then your brother needs to submit his power of attorney to Mr. Khan's office, and then he would need to file his response.
Okay.
And so that way we can go ahead and move forward. And we'll go ahead and set a status hearing for September the 26th.
September 26th.
At 9:30.
May I check my calendar, Your Honor?
Sure, that will be in person.
Yes. Your Honor, I am scheduled for a pretrial in another case on that day at 9 a.m.
Okay, October 3rd?
That's the trial, the case that I'm set for the pretrial.
How long is your trial?
2 or 3 days.
Oh, okay. So we have a docket on the 10th, October 10th?
October 10th, but that's Columbus Day or Indigenous Peoples' Day. If the court's open, I'm available.
I don't know, I'm not setting, let me see. Yeah, they
We're
are.
available October the 12th.
It would be the 12th then,
Okay, October 12th.
at 9:30.
Okay,
All right, if nothing further, then I'll give you the opportunity to be able to submit that or have your brother do that.
Okay, thank you.
Okay, all right.
thank you, Your Honor. May I be excused?
Yes, you may.
Thank you, Your Honor.
Okay, Mr. Skaggs, what do you have, sir?
It's number 46 on your list.
Okay. It's CL 193806-I, One Main Financial versus Miguel Esparza.
Yes, and I have filed a motion to withdraw as counsel. I've been unable to satisfactorily communicate with the client, and we have differing views on the defense of the case. And I served him with a copy of the motion and the notice of hearing, and I have received no response on it.
Okay, and is someone here on behalf of One Main? Okay. All right, then your motion to withdraw is granted.
And I did submit a proposed order for the court's signature.
Okay, I'll have that forwarded to my queue, Mr. Scaggs.
Okay, and that's all I have with the court this morning.
Okay, and I'm just gonna reset this for September the 12th at 9:30, and if no one responds by then we'll see where we take it from there.
Okay.
Okay, thank you.
Your
You
Honor.
have a good day.
May I be excused?
You certainly may.
Okay, thank you.
Thank you. Okay, Ms. Flores is back on.
Yes, Judge.
Okay.
Good morning.
Good morning. Let me go ahead and recall that case. I'm sorry, what number was that?
Number 20.
Okay, CL 220257-I, Brenda Sandoval versus Noé Cifuentes et al.
Martin Perez representing Ms. Sandoval.
Okay, hold on. And before you go on, is that Ms. Sandoval on there with the Samsung?
I believe so, but I'm not sure.
Is she English speaking or Spanish speaking?
Spanish speaking, Judge.
Okay.
Spanish speaking.
Ms. Castañeda, please let her know that she needs to get somewhere where we have no background noise because I'm hearing a lot of noise.
Ms. Sandoval, ¿se puede mover por una área donde no tengan ruido atrás porque estamos agarrando mucho ruido atrás?
Sí.
Okay, continue with announcements. Ms. Garcia, go ahead.
Yes, Cindy Garcia on behalf of the defendants, Your Honor.
Yeah. Ms. Flores?
Your Honor, Vanessa Flores, I'm the guardian ad litem appointed to represent the child in this case.
Okay, you're frozen right now. So I don't know. If you can hear, you can have your video off. So that maybe that'll help.
I can hear Your Honor. I'm inside the courthouse, so maybe that's why.
Okay. All right, go ahead, Mr. Perez. Just question your client slowly so that Ms. Castañeda can translate. Let me go ahead and have her raise her right hand.
Ms. Sandoval, por favor, levanta su mano derecha, Ms. Sandoval.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Toda la verdad.
All the truth.
Okay, go ahead and lower your hand.
Puede bajar su mano.
You may proceed.
Okay, can you state your name for the record?
Por favor, diga su nombre completo. Brenda Evangelina Valle Sandoval.
And you are the mother of, oh my gosh. Can you state the name of your daughter?
Por favor, diga el nombre de su hija.
Karime Monserrat Zúñiga.
And she was involved in an accident with the defendant Noé Cifuentes on April 26, 2020. Is that correct?
Y su hija estuvo involucrada en un accidente el día 26 de abril del 2020, ¿correcto?
Sí.
Yes.
Okay. And you understand that you have agreed to resolve this matter resolve this matter in a settlement agreement. Is that correct?
¿Usted ha llegado a un acuerdo tocante este caso?
Sí.
Yes.
And that amount is $9,305. Is that correct?
Y la cantidad que se llegó al acuerdo es $9,000 $350, correcto. 305, ¿correcto?
Sí.
Yes.
And you understand that after medical expenses are paid, case expenses are paid, the total recovery to your daughter is $1,403.15.
Y está usted pendiente que después de recuperar los costos médicos y de los abogados, la cantidad que va a quedar van a ser $1,403.15, ¿correcto?
Sí.
Yes.
And you understand that is going to be put into the registry of the court?
Y usted entiende que este dinero se va a poner en el registro de la corte, ¿correcto?
Sí.
Yes.
And our office really explained that to you, is that correct?
Y la oficina le explicó esto, ¿correcto?
Sí.
Yes.
You understand that you didn't have to agree to this settlement. You understand that, right?
Y usted entiende que no tenía que aceptar este acuerdo, ¿correcto?
Sí.
Yes.
You have done this because you feel that there's no further future medical expenses for your daughter. Is that correct?
Y usted llegó a este acuerdo porque usted cree que ya no va a haber costos médicos en el futuro, ¿correcto?
Sí.
Yes.
And you understand that this finalizes this claim against Mr. Cifuentes, the defendant.
Y usted entiende que esto finaliza el caso con el señor Cifuentes.
Sí.
Yes.
And you understand that you can't come back in the future against Mr. Cifuentes regarding this matter.
Y usted sabe que no puede venir otra vez contra el señor Cifuentes tocante este caso, ¿correcto?
Sí.
Yes.
Now, I discussed with you on Friday a bill involving 911 pain management. Do you remember that conversation?
¿Recuerda usted una conversación que tuvimos el viernes tocando pago para 911?
Sí.
Yes.
And what we discussed was you didn't feel that your daughter visited that facility. Is that correct?
Y usted dijo que usted no creía que su hija había visitado ese lugar, ¿correcto?
Sí.
Yes.
And after reviewing the records with you, I explained to you that you didn't visit physically, but it was a telemedicine appointment.
Y después de revisar los documentos, no fue una visita física, fue telefónica, ¿correcto?
Sí.
Yes.
Okay, and I explained to you that their bill for that telemedicine appointment was $1,260, but that our office had acquired a reduction from them and that the bill was reduced to $400. Is that correct?
Y sí recuerda que por esa visita telemédica eran 1,260, pero ellos estuvieron de acuerdo a rebajarla a $400, ¿correcto?
Sí.
Yes.
Are you in agreement with that reduction?
¿Está usted de acuerdo con esa reducción?
Sí.
Yes.
Okay, and you're in agreement with the recovery of $1,403.15 for your client. Is that correct?
Y está usted de acuerdo con la cantidad de 1,403.15 centavos?
Sí.
Yes.
Okay, and are you asking the court to approve this settlement?
Y usted le está pidiendo a la corte que apruebe este arreglo?
Sí.
Yes.
I pass the witness, Judge.
Okay, Ms. Garcia, any questions?
Yes,
Okay, go ahead.
yes. Yeah, you're aware that you're entitled to have a trial in front of a jury if you chose to do so, correct?
¿A usted está de acuerdo que usted tiene el derecho de proceder con un juicio por jurado, correcto?
Sí.
Yes.
And if you did proceed that way, you would either be awarded the same amount that you're getting now, less than that amount, or possibly zero. Are you aware of that?
Y usted entiende que si procedían con un caso de jurado puede agarrar la misma cantidad, menos o cero, ¿correcto?
Sí.
Yes.
And you have chosen, agreed with your attorneys, and you have met with the ad litem and have agreed that this settlement is in the best interest of your children, and you're willing to accept it.
Y después de revisar con sus abogados y con el ad litem, usted va a aceptar este asentamiento, ¿correcto?
Sí.
Yes.
Okay. Do you understand that, and you may have been asked this, I didn't know if I heard it or not, but the total amount that's going to be entered into the registry of the court on behalf of your daughter is $1,403.15.
Y sí entiende que la cantidad, a lo mejor ya se repitió, pero es 1,403.15 centavos, ¿correcto?
Sí.
Yes. And the rest of the 9,305 goes to your medical expenses and attorney's fees.
Y lo demás de los 9,305 va para los abogados y para los expenses, gastos médicos, ¿correcto? Yes.
That's all I have as far as questioning, Your Honor, but I did notice that there is not an amount in the proposed judgment that we have for ad litem fees. So I just wanted to make the court aware of that. That's not documented in the amounts so far.
Okay, Ms. Flores, do you have any questions of the plaintiff?
Your Honor, just a few.
Go ahead.
Okay. Okay, Ms. Sandoval. I spoke with you in reference to this case, is that correct?
Ms. Sandoval, yo hablé con usted tocante este caso, ¿correcto? Sí. Yes.
And in reference to your daughter Karime, is that correct?
Y en referencia con su hija Karime, ¿correcto? Sí. Yes.
Okay, and the only issue that you had brought up was the issue of some treatment from 911 pain management, is that correct?
Y el único problema que usted me había dicho era del 911, la oficina del 911 que visitaron, ¿correcto?
Had I not done that, I would have passed for sure.
Hold on. Okay, go ahead.
But that was clarified by Mr. Bettis, or I guess when he was questioning you, is that correct?
Pero eso se clarificó con el señor Pérez cuando le estaba preguntando, ¿correcto? Sí. Yes.
Okay, and Karime has completely healed from any injuries received as a result of the accident, is that correct?
Y Karime ya está completamente bien el resultado del accidente, ¿correcto? Sí. Yes.
And you believe that this settlement is in the best agreement for your daughter, is that correct?
¿Y usted cree que este asentamiento es para el mejor de su hija, correcto? Sí. Yes.
Okay, Your Honor, I have no further questions. I did speak with Ms. Sandoval in reference to that particular issue. I did get in contact with Mr. Davila's office in reference to it. I believe that they had a conversation with her. But other than that, Your Honor, I was in agreement and approval of the settlement. I do believe it is in the best interest of this child, Your Honor, and I'm asking the court to approve it.
Okay, and Ms. Garcia did mention that your ad litem fees still have not been agreed to. Do you anticipate you all will come into an agreement for that?
Your Honor, I have not had the opportunity to speak to her. I can reach out to her, or I'm not.
Okay.
I don't think we're gonna have a problem. I just wanted to make sure that we get it documented. It's not in our proposed judgment or settlement agreement.
Okay, Ms. Flores, if you can contact her so that they can go ahead and put that into the order.
Yes, Your Honor.
And then you all can sign off. Please make sure that everybody signs off on it. Okay, all right,
Yes,
Ms.
sure.
Castaneda, please let her know that she'll receive the documents to sign off on.
Sandoval, le van a pasar los documentos para que los firme. Sí. Yes.
All right. Okay, if nothing further, then you all may be excused.
Thank you, Your Honor.
Thank you. Okay, tell her that she's excused.
Ms. Sandoval, ya se puede retirar. Gracias. Thank you.
Okay, Miss Ileana Hernandez, your attorney already showed up for you and made the announcement. So if you can contact him, then that way you don't have to stay waiting anymore.
Okay, thank you.
All right, thank you. Okay. Let me see, Rolando Fernandez.
Yes, Your Honor, I'm here.
Okay, what case do you have?
Doc number 60.
Okay, F1029-22-9. And I believe, was that going to be a name change?
Yes, I'm trying to put it together instead of spaced out.
Right.
Yes,
And so we were just missing your criminal history report, correct?
correct. And I submit.
Okay, so has that been submitted from Austin?
Yes, and I called the office at Hidalgo and they said they had it in files.
Okay, so Ms. Rivera, can you just verify for me that we've received the criminal history report? Or Ms. Castaneda?
Your Honor, we have, it was filed on June the 6th.
Okay, and so it shows no criminal history, correct?
Correct. Correct.
All right. Okay, so then, let me go ahead and swear you in. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes,
Okay, go ahead and lower your hand. So you're the petitioner in this case where you're asking for a name change, is that correct?
that is correct.
And you are asking for your last name to be changed to Fernandez de Lara, but all one name, is that correct?
Correct. No spaces, no capital letters in between.
Okay, and you are not doing this to avoid any type of criminal prosecution, is that correct?
That is correct.
Okay, and so do you have an order on file?
Yes.
Okay,
Order
so I'll ask for that order to be forwarded to my queue. And I'm going to grant your name change.
Thank you, Your Honor.
Okay, anything else?
No, that's it.
All right, thank you, sir. You have a good day.
Thank you, you too.
All right, Andrew Smith,
Good morning, Your Honor.
good morning.
I have 4 defaults on the docket. If I could have those heard, please.
Okay, hold on really quickly. Ms. Palacios Cruz, do you just have one case?
I do, Your Honor. It is a quick announcement.
What number?
Your Honor, I don't know the number on the docket. It is CL 16-1080. I'm sure it's 9 now, though. No, it's actually still I.
Okay.
Judge, I think that's 39 on the docket, and I think I'm on the
Yes.
other side.
Midland Funding versus Rodolfo Celedon. What is the announcement?
Your Honor, we're just asking for more time. We haven't been able to get in contact with opposing counsel. I believe the number is just like an automated system. So I'm happy to see Mr. Brogan here.
Yes.
Mr. Brogan, is there a direct number that they can call maybe?
Yes. My number, Ms. Cruz, is 262-796-6925, and I'll send you my email in a chat so you have that.
Perfect. Thank you so much.
Sure.
Okay, so I'm gonna hold the status conference over till September the 26th at 9:30.
Thank you, Judge.
Okay, anything else?
Nothing further, Your Honor, if I may be excused.
Yes.
Thank you, Judge.
Okay, you're welcome, ma'am. All right, so Mr. Banker, what do you have? Because the one, Mr. Smith and Mr. Brogan have multiple cases, so before I take those, Mr. Banker, are you still with us? All right, Mr. Reina, what do you have, sir?
Good morning, Judge. I have number 38 on your docket. I logged in late, Judge. I don't know if it's been called. Sergio Munoz is on the other side.
No, it hasn't. CL 153093-I, Lury, Lury, Alejandro Duarte et al. Versus Jose Luis Soto.
I don't see Mr. Munoz online, Judge. We've not gotten together to mediate this case. This is an older case. I represent the defendant. The plaintiff sued my client because the plaintiff's property was sold.
Yes,
by my
I
client.
remember the case, but why haven't you all gone to mediation? That mediator has been assigned for quite some time.
We tried getting a hold of Mr. Munoz, Judge, and that was their issues. He wouldn't return our calls. And then Mr. Munoz and I haven't been able to agree on a mediator other than JR.
Okay, but the mediator, I assigned the mediator. The mediator is Mr. Hernandez, isn't it?
You had appointed JR Garza, I believe, Judge. I haven't received anything other than.
Okay, you should have received, I know that you all had issues with that. So
Yes.
then I appointed Daniel Hernandez. Was a mediated order not sent out to you with that?
I'd have to look, Judge. I don't remember seeing it, but I can check real quick. Well, in any case, it hasn't been done, Your Honor, but
Okay, hold on, Ms. Rivera?
Judge, I don't see that meeting, the order of referral for Mr. Hernandez, Your Honor.
when did it go out?
Okay. So we need an order, that should have been prepared. So the order of referral to Daniel Hernandez needs to be prepared and sent over. And mediation will occur within 60 days. And you will have a status hearing on September 12th.
Thank you, Your Honor.
So if mediation has not occurred by September 12th, the party that has not attended mediation, I will consider sanctions against them.
Very well, Judge.
Okay,
That's all I
anything
have,
else?
Judge. No, Judge.
Okay, thank you, Mr. Reyna.
Thank you.
Okay, Ms. Frias?
Good afternoon, Your Honor. I'm Ivana Frias on your docket. I'm number 10.
Okay, that's F0781-22-9 in the interest of Ivana Frias. Okay, did you prepare something and file it on your own?
Yes, Your Honor.
Okay, and what was it?
It's the original joint petition for adoption of an adult and change of name for an adult. On this call, there's also petitioner number 1, my stepfather, which is the person that I want to adopt me.
Okay, so no action has been taken on your case and we had, so what do you want to do with it?
I would like to reinstate the case and go through with it so I'm able to be adopted by him and change my name.
Okay, so how much time do you need in order to get like a waiver on file, or do you have a waiver on file?
I don't have a waiver, I believe, but I can get that by the end of today.
Okay, so I'm going to allow you to continue to proceed with your case. And I'm going to set you for a status on September the 12th at 9:30. That will be in person. And so if you have everything ready before then instead of a status, we'll go ahead and do a final hearing. And your stepfather needs to also attend.
Yes, he's in the call as well.
Okay. All right. So he'll also need to attend so that we can take his testimony.
All right, perfect. And that will be.
And that will be in person.
Okay, perfect. Thank you.
All right. Anything else?
That's it.
Okay. Then you have a good day and we'll see you then.
Thank you. Likewise. Bye.
Okay. So Mr. Sines, you never had your hand up or anything. I'm not sure. Are you here in a case?
Yeah, I was with Ivana, but I'm leaving.
Oh, okay. So Mr. Sines, you are the stepfather?
Correct.
Oh, okay. So you will be then going to sign off then with Ms. Frias, correct?
That is correct.
Okay. So then we'll see you in person then on September the 12th at 9:30.
Correct.
Okay.
Thank you.
All right. Thank you. We'll see you then. Okay, Mr. Banker, what case?
Judge number 9 on the docket, Carla De Leon. And it's on the drop docket, Your Honor, because this case I had filed an answer a few months ago, and the plaintiff never. We've tried to communicate with him, and nothing's ever happened. So you put it on the drop docket, as far as I understood.
Yes. Is anyone here for Midland Credit Management versus Carla, KRLA De Leon? Okay. Well, since no one is here on their behalf, then we'll go ahead and I'm dropping it then. For
Your Honor, be excused.
Yes, sir. Okay, Miss Teresa Max Vasquez, I do have a couple of other attorneys with several cases. So before I go to them, do you have just a quick announcement?
Your Honor, good morning. No, I actually have 5.
Okay. All right, then I'll have you on that line of people.
Okay.
All right, Mr. Gibson, do you have just a quick announcement?
I'm kind of, let's see, trying to get this thing started.
I was on a TWAP docket as well today, Your Honor. I haven't.
Yes, that's number 4, CL 1743888-I, Anthony, Antoni, Jakobski, Jakobsze et al. Versus Puloa, Puloa LLC. I'm sorry.
Yeah.
Anyone here on the defense?
I don't see Mr. Escobedo.
Okay, and what is the
This is-
announcement?
We're ready to proceed and get a trial date on the matter, Your Honor. I think this DWAP was set up as a result of me missing a status hearing last month. I was a few minutes late to the hearing, and I guess they already called it. So they set up for a DWAP, but we can file a DCC and get a trial date if not already set on the case, Your Honor.
Okay, go ahead. Go ahead and file a motion for DCC so that we can get that done.
Okay. All right. Well, I'll have it done today, Your Honor.
Okay.
Thank
And
you.
then I'm gonna set a tickler for July the 15th.
Okay. Thank you, Your Honor.
All right. Okay, thank you. Yes.
Thank you.
Okay, Ms. Cedillo, what do you have?
Good morning, Your Honor. I'm here on a contested matter. I'm here on number 34 of your docket. Opposing counsels here, cause number CL 21-4285I. We're here to argue a motion for summary judgment. I anticipate it's probably going to take anywhere, maybe about 15 to 30 minutes.
Okay, a motion for summary judgment for a contested shouldn't have been set for this docket, or at least those have been, the contested ones have been on in person.
And that's what we were under the impression as well, Your Honor. Originally, we were told in person. I actually am in the Valley right now. But we got the Zoom link on Friday, so we just assumed that the court wanted to go forward with the Zoom link. And I know opposing counsel and I are never going to question a court's decisions.
Okay, so who's here on behalf of the defendant?
Good afternoon, Your Honor. This is Rafael Casada for the defendant.
Okay. All right, it says I'm picking a jury at 1:30. So I was trying to see how far we could get. I know you all have been on. And Ms. Cedillo, originally, where are you from?
I'm from the Valley, Your Honor.
Oh, okay, so you're
Originally,
here.
I just had to move to El Paso for work.
No,
with
but
Longhorn.
where are you? So are you now practicing in El Paso?
Yes, but I'm still coming back and forth for cases as needed here in the
Okay.
Valley.
All right.
So good to be back with humidity.
All right, well, let me just see then. I'm probably just be on standby. I'm gonna try to see how I can get these. I honestly don't know what to do because I'm trying to get finished with the docket from this morning, and then I have picking a jury at 1:30. And you all are gonna take about 30 minutes on this contested matter. And you're here right now, but you're not going to. Did you file a response, Mr. Casada?
It is our motion for summary judgment. They filed a response and we filed a reply
Okay. And so are you practicing here in the Valley?
in Houston.
Oh, so you're in Houston. Okay. All right. Okay. And you all don't have local counsel?
No, Your Honor, we will.
It would
try.
be you. It would be you that needs to come down, in other words.
Correct.
Okay. All right. Well, then just be on standby. Let me try to go through the other ones as quickly as possible, and then I'll take you up.
Yes, Your Honor.
Been on already. Okay, Mr. Smith, go ahead. Which are your cases?
First up is number 28, Your Honor.
All right, CL 21-3139-I, Discover Bank versus Ricardo Rodriguez.
All right, Your Honor, this one we moved for default judgment. The complaint was filed with the court on or about September 8th, 2021. Service was accomplished on March 22nd, 2022, and the return of service has been on file for the requisite amount of time prescribed by law. Being that there is no answer filed with the court, plaintiff requests default judgment in the amount of $4,081.33. post-judgment interest at 5% per annum, and cost of court at $370.15.
Okay, Ricardo Rodriguez. Okay, I'm sorry, cost of court and what else?
Post-judgment interest at 5% per annum.
Okay.
And then
And
we've got the non-military affidavit in the file. We have the certificate of last known address in the file, as well as a business records affidavit to prove up damages.
Okay, and is the order granting on file?
Yes, Your Honor.
Okay. Then the court is taking judicial notice of the documents on the court's file, and that'll be granted, and I'll ask for that to be forwarded. Your next case?
My next one, Your Honor, is 31. And
CL,
I do see the defendant, Ms. Chapa, here in the Zoom room.
CL 214138-I Discover Bank versus Ruby Chapa. Ms. Chapa, are you present?
Yes, ma'am. Yes.
Okay. Ms. Chapa, I'm going to give you an opportunity to speak to a representative from Discover Bank. Do you have something to write with?
Yes.
Okay, go ahead. What is the contact info?
Good phone number, ma'am, is 866-367-9942.
Okay.
Okay.
And Your Honor, for this one, the defendant has reached out. We do have records of her calling in to try and negotiate. We haven't worked out anything. But if Your Honor would like to consider her appearance as an answer, then we can proceed that way.
Okay, so I'm going to set you for a status on September the 12th at 9:30. That'll be in person, and I'm going to consider her appearance as an answer. So you need to get something worked out before then, Ms. Chapa.
Okay.
Okay, if nothing further, you're excused.
Okay, thank you.
All right, your next case?
Number 32, Your Honor.
CL 214203-I Discover Bank versus Francisco Ruiz. Francisco Ruiz. Okay, go ahead.
Thank you, Your Honor. This one was filed on or about December 22nd, 2021. The defendant was personally served on, December 30th, 2021. The return of service has been on file for the requisite amount of time prescribed by law. Being that there is no answer on file responding to plaintiff's petition, plaintiff requests default judgment in the amount of $7,626.72, post-judgment interest at 5% per annum, and costs of court in the amount of $370.15. Plaintiff requests the court take judicial notice of the business records affidavit on file, proving up damages, the non-military affidavits, and the certificate of last known address. And there is a proposed order on file, Your Honor.
Okay, the court is taking judicial notice of all the documents in the court's file. Specifically, the service was perfected and no answer was filed on behalf of the defendant. Therefore, the relief as requested on the record is granted.
Thank you, Your Honor. And then I've got one more, number 33.
CL 220038-I Discover Bank versus Carmen Musquiz, MUZQUIZ, Carmen Musquiz. Go ahead.
All right, thank you, Your Honor. This cause was filed on or about January 4th, 2022. Service was accomplished personally on January 15th, 2022, and the return of service has been on file for the requisite amount of time prescribed by law. Given that there has been no answer filed in response to plaintiff's original petition, plaintiff requests default judgment in the amount of $9,680.37, post-judgment interest at 5% per annum, and costs of court at $448.35. Plaintiff requests the court take judicial notice of the business records affidavit on file, proving up damages, as well as the non-military affidavits and the certificate of last known address.
Okay, the court is taking judicial notice of the documents in the court's file, specifically that service was perfected. No answer was filed on behalf of the defendant, and the defendant is not present. Therefore, the relief as requested and put on the record is granted.
All right, thank you, Your Honor. And that's all the business I have before this honorable court. May I please be excused?
You certainly may.
Thank you, Your Honor.
Okay, thank you. Mr. Brogan, let's take up your cases.
Okay, thank you, Judge. The first one, the defendant is here, number 2 on your docket.
Okay, CL 170633-I Portfolio Recovery Associates versus Cassandra, CASSANDRA Luna. Ms. Luna, can you hear me?
Yes, ma'am.
Okay, Ms. Luna, do you want an opportunity to speak to somebody from the plaintiff side?
Yes, I had previously, I had been here before and I had been trying to make contact with him. Unfortunately, I did make contact with him. I think it was only on a holiday. And then after that, when my reattempts or my voicemails, they were left unanswered. So if I can attempt again with another individual, that'd be great.
Okay.
Judge,
Ms.
I'm gonna
Go
give her
ahead.
my email in the chat. If she can contact me by email, I can set up a
Yeah,
time
of
to
course.
talk or discuss. So I'm gonna send a chat message, Ms. Luna, to you with my email.
Okay, I got it.
Okay.
All
And
right.
Judge, if we could have a reset of this hearing.
Well, yes, September 12th at 9:30 for status.
Okay.
And
I'm
that
sorry.
is in person, Ms. Luna.
Okay.
Okay, anything else? Not on her. Okay, Ms. Luna, you are excused.
Thank you, Judge.
Okay, go ahead, Mr. Brogan.
Yes, Judge, I have number 3 on the docket.
CL 170759-I Portfolio Recovery versus Laura Noriega.
Judge, I understand that we are asking that this case be retained and set for a default judgment hearing, and an order setting hearing has been filed.
Okay, so if an order setting hearing has already been filed on that default judgment, we'll go ahead and get that set for you.
Okay, thank you.
Okay,
And
next.
sorry, the next one is number 5.
CL 175118-I LVNV Funding versus Ryan Hoover.
Same announcement, Judge. We have an order setting hearing. We're asking it be set for default.
Okay, so that was already filed.
Yes, I believe so.
Okay, all right, since that's been filed, we'll go ahead and set that for you.
Thank you. The next one is number 6.
CL 180544-I Portfolio Recovery Associates versus Eustolia EUSTOLIA Ornelas.
Same announcement, Judge.
Okay, and then we'll get that set for you.
Thank you. Number 7, and then I also have number 8 after.
CL 184128-I Portfolio Recovery Associates versus Leonel De Leon.
Same announcement.
Okay, we'll set that default judgment. CL 210924-I Discover Bank versus Daniel Cepeda, CEPEDA.
Same announcement, Judge.
All right, the order setting hearing on default judgment will get set. Okay, go on.
My next is number 21.
CL 164601-I Midland Funding versus Michael Rodriguez. Michael Rodriguez, go ahead.
We're trying to proceed on a default judgment. Can I proceed?
Yes.
Okay. We should have the motion in order and everything on file, Judge. We filed suit November 30th, 2016. Service was December 14, 2016. The original account was a Best Buy account, opened January 30th, 2008. Last payment date was June 21st, 2014. And the charge-off date was December 16th, 2014. And we're seeking $1,562.63.
Okay. The court is taking judicial notice of all the documents in the court's file, specifically that service was perfected. The required amount of time has passed. So the court is granting the relief as requested. All right, next. Mr. Brogan, you're on mute.
I'm sorry, Judge, I had an issue.
Okay.
Can you hear me now?
Yeah, I can. The next case.
The next is number 22.
CL 191630-I Capital One Bank versus Ira, EIRA Jimenez.
Judge, this is set for status. We're asking for a trial date.
No,
she's
it's
here.
set for a motion for default judgment.
Okay, I see that she is present.
Yes. Ms. Jimenez, can you hear me?
Yes.
Okay, Ms. Jimenez, do you want an opportunity to speak to the attorneys from Capital One?
I've been trying to get a hold of him since April. I left messages, but nobody has called me back, so I don't know if I can still speak with them or.
Yes, Judge. I'll send Miss Ira Jimenez my email and a message. If she can email me, we can set up a time to talk or discuss via email. I'm gonna send her my email right now. via
Okay,
chat.
so you should see something pop up on your chat, okay? He's gonna send you the email on the chat.
Okay.
And I'm gonna set this for status on September the 12th at 9:30, and that's in person. If you settled it before then, you don't need to show up, but if not, you need to show up, okay?
Mr. Brogan, it's C Brogan at what?
If you pull up the chat, you should be able to see it again, but it's RSIEH.com.
Okay. All right, I'll go ahead and get in touch with you.
Thank you.
Okay, so we're gonna set you for a status on September the 12th at 9:30, okay?
Okay.
All right, then you are excused, ma'am.
Thank you.
Thank you. Okay, your next case?
My next is the next one, number 23.
CL 21400-I Crown Asset Management versus Julio Gonzalez. Julio Gonzalez, Julio Gonzalez. Go ahead.
We're trying to proceed on a default. May I, Judge?
Yes.
Okay. We filed suit March 12th, 2020. We got service March 21st, 2020. The original account was a contract with Payne Mission. It's an automobile case. It was entered into July 21st, 2015, charged off July 31st, 2018. Today, we are seeking $6,998.63 plus post-judgment interest. It should all be on the order, Judge.
Okay, so the court is taking judicial notice of the documents in the court's file, specifically that service was perfected. No response was filed on behalf of the defendant. Defendant's name was also called out 3 times and no response. So the relief as requested is granted. Okay, your next case?
My next is number 25.
Okay, that is CL 21648-I Portfolio Recovery versus Elvia, ELVIA Saavedra, SAAVEDRA.
Judge, this case is settled. We don't have the agreed judgment back from the defendant. We would ask for a reset to try to get that agreed judgment signed.
Okay. And how much time are you requesting?
60 days. She is making payments. We just need to get that agreed judgment.
Okay, I'll go ahead and set a tickler for August the 26th.
Okay, thank you.
Okay,
And
your next case?
number 26, the next one.
CL 21877-I Portfolio Recovery Associates versus Ida AIDA Sanchez. Ida Sanchez. Go on.
This is a default judgment. May I proceed?
Yes.
Okay, we filed suit April 21st, 2020, service May 22nd, 2020. Excuse me. The original account was JCPenney, opened February 14, 2017. Last payment date was January 19, 2018. And the charge-off date was July 23rd, 2018, and we're seeking $1,048.41.
Okay, the court is taking judicial notice of the documents. Give me one moment.
Sure.
All right. So the court is taking judicial notice of the documents in the court's file, specifically that service was perfected. No response was filed on behalf of the defendant. And the relief as requested is granted. Okay, your next
Thank you.
case?
I only have 2 more, Judge,
Okay.
and they're both brief. Number 43.
CL 1865556-I Capital One Bank versus Juan Tristan III. Juan Tristan III. Go ahead.
This case is settled, Judge, and there's a payment plan, payments being made, but we don't have the agreed judgment. If we could have this reset in 60 days to get that taken care of.
Okay, I'm gonna set a tickler for August the 26th because this is the second setting that they requested for the documents to be submitted.
Okay.
So a tickler on this one and the other one, that means you don't show up. It's just gonna, we'll check on you all.
Okay, thank you.
Okay, your next one?
This is my last one, Judge, number 50.
All right, CL 202053-I Crown Asset Management versus Ermelinda, IRMELINDA Peña.
Same announcement for this, Judge, if we could get the same tickler for August 26th.
Okay, so it's settled already?
Yes.
Okay. Okay. And anything else?
That's all I have, Judge. Thank you. May I be excused?
Yes, you may.
Okay, thank you. Take care.
Thank you. Okay, Ms. Martinez, Elma Martinez.
I'm muted still.
No, I can hear you, Mr. Martinez. Okay, Elma Martinez.
Un momento, me voy a parquear.
Okay, Ms. Castaneda, you'll need to translate.
Just to give her a second, she's parking.
In the meantime, are all the documents filed in this?
Ya estoy aquí.
I'm here.
Let her know that we're checking to see if everything is on file.
La corte está checando si todos los documentos están en el caso.
Está bien.
That's fine.
Judge, I'm not seeing the cause number on this one. Oh, I found it.
It's number 12 on the court's docket, F5286-21-9.
Yes. I found it.
Okay, so did they have an original petition for divorce on file, correct?
Correct, Judge, with a waiver that was filed on March 21st, 2022.
Okay.
With Mr. Martinez's signature.
Is there a divorce decree?
No, Your Honor, nothing has been filed. This
Okay.
default setting was a result of no appearance on May 16th, Judge.
Okay, Ms. Castaneda, ask Ms. Martinez if she's going to be filing a divorce decree.
Yes. Señora Martínez, ¿va usted a hacer o meter una orden del divorcio?
Sí.
Yes.
Okay, but she hasn't done that. So do they have any property together?
Pero no lo ha hecho. ¿Tienen propiedad juntos?
No.
No.
And do they have any debts together?
¿Tienen deudas juntos?
No.
No.
How long were they married?
¿Cuánto tiempo estuvieron casados?
Ay, desde el 97.
Since 97.
So from 1997 to now, they haven't accumulated any property?
So desde el 97 hasta hoy no acumularon propiedad?
No, porque mi suegra nos había regalado una propiedad, pero yo firmé para dársela a él porque la iba a vender.
My mother-in-law had given us a property, but I signed it over to him.
Okay. And have they already been separated for more than 6 years?
So han estado separados por más de 6 años?
Desde el 2016.
Since 2016.
Okay, let me go ahead and just have them both raise their right hand. Mr. Martinez, are you English speaking or Spanish speaking?
English is fine.
Okay, Ms. Castaneda, please have Ms. Martinez raise her right hand.
Ms. Martínez, por favor, levante su mano derecha.
And is there a way for her to start her video so I can see her?
¿Puede prender su cámara, Ms. Martínez?
Sí,
Okay, do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, Mr. Martinez? Yes or no?
Yes.
You can lower your hand. Go ahead, Ms. Castañeda.
Ms. Martínez, ¿jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad?
sí,
Yes.
She can lower her hand.
Puede bajar su mano.
Okay, at the time that she filed for divorce, was she living in Hidalgo County for at least 90 days and in Texas for at least 6 months?
Al tiempo que usted metió su petición, estaba viviendo en el condado de Hidalgo por 3 meses y en el estado de Texas por los precedentes 6 meses.
sí,
Yes.
And you're currently married to Jose F. Martinez III?
Y ahorita está usted casada con José F. Martínez III.
sí,
Yes.
And she was married on or about, let me see, August 22nd, 1997, and ceased to live together as husband and wife on August 1st, 2016.
Que ustedes se casaron el 22 de agosto de 1997 y dejaron de vivir juntos como marido y mujer agosto 1 del 2016.
creo que sí, ya no recuerdo
think yes.
exactamente.
I think yes, I don't remember the exact time.
Well, that's what she has on her petition.
Es lo que tiene en la petición.
Sí,
Yes.
Okay, and do you and your husband have any minor children?
¿Usted y su esposo tienen niños menores?
mi hijo tiene 20 y mi hija 21.
My son has 20 and my daughter 21.
So they do not have any minor children, correct?
So no tienen hijos menores de edad, ¿correcto?
Correcto.
Correct.
And is it her testimony that they do not have any community property together?
Y es su testimonio que no tienen propiedad comunal juntas?
No, no tenemos.
No, we don't have.
Is she currently expecting a child?
¿A este momento está usted esperando bebé?
No,
No.
And do her and her husband have any community property debts that they need to divide?
¿Y usted y su esposo no tienen deudas comunales que tienen que dividir?
no,
No.
So she'll be responsible for any debts under her name, and he'll be responsible for any debts under his name?
So usted se va a ser responsable por las deudas que tienen su nombre y él por las deudas que tienen su nombre.
sí,
Yes.
Okay. Then is she asking the court for divorce today?
¿Está usted pidiéndole a la corte un divorcio hoy?
sí,
Yes.
Okay. And Mr. Martinez, you've heard the testimony of your wife. Is that your agreement?
Yes, Your Honor.
Okay. So now I need, let her know that they need to file a divorce decree that's signed by them.
Necesito que por favor llenen el decreto firmado por los dos.
está bien.
Okay.
And tell her that I'm only giving her until July the 15th to turn it in.
Y nada más le voy a dar hasta el día 15 de julio para que lo entregue.
Está bien.
Okay.
All right. Okay, so tell her that I'm granting the relief as requested. Is she asking for a name change?
Okay. La corte va a aprobar el divorcio. ¿Está usted pidiendo cambio de nombre?
No,
No.
Okay. Then I'll give her till July the 15th so that they can submit the divorce decree. And then that's when, once I sign the divorce decree is when they are divorced.
Okay. Tiene hasta el día 15 de julio para presentar el decreto y hasta que yo lo firme es cuando están divorciados.
está bien.
Okay.
Okay, if nothing further, they are excused.
Okay, ya se puede retirar.
Gracias.
Thank
Thank
you.
you, Your Honor.
Yes, sir, you're welcome. Okay, Ms. Cárdenas, Ana Cárdenas.
Yes.
Okay, what number are you on the court docket? Do you know? Ms. Cardenas, do you know what number you are? You're number 17. Okay. Are you ready to proceed on your divorce?
Yes,
Do you have children?
yes,
Okay, is there a case with the Office of the Attorney General?
yes.
Okay, then you need, and what court is that in?
I'm sorry?
What court is that in?
That I'm not too sure.
Okay, can you all look up the case and see someone in my office if there's already an order with the Office of the Attorney General somewhere?
Yes, Judge, 1 second. Judge, I don't see that that there was an intervention by the OAG's office.
Okay, was there an order signed at all?
No, Judge.
Okay, have you been receiving child support, Ms. Cardenas?
Yeah, we came to an agreement.
Okay, but do you receive it through the Office of the Attorney General?
No, I filed in September, but I haven't received anything.
Okay. So, have you filed a divorce decree?
Yes,
And does it have the signatures of you and Mr. Cardenas?
yes.
Okay, let me just have my staff verify that.
That's correct, Your Honor.
Okay,
The waiver.
all right. And in that divorce decree, does it set forth the child support and the visitation?
Yes, we came to an agreement.
One second.
Okay, I'm just having my staff check it.
I don't see an amount
specified-
here.
Yeah,
There's
there's
not
no
an amount
specified
on here.
amount.
Okay, one at a time.
There's no specified amount, Judge.
Okay. You do have a divorce decree on file, but you haven't set the child support amount, and I can't divorce you unless that's put on there, and he already signed it. So you need to file an amended divorce decree that has the amount of child support that he will be paying.
Okay.
Okay, and I'll give you some time to do that. How long have y'all been separated?
A few years already.
Oh, okay. I don't believe, let me see. Well, I'll have you come back on August the 17th at 9:30, but that is in person. And make sure you have it filed and signed by him before then.
Okay.
All right?
Yes, ma'am.
All right, thank you, ma'am.
Thank you.
Okay, I think we're ready for you, Miss Max Vasquez.
Okay.
Okay, what numbers?
Good afternoon. Okay, yes, Your Honor. The first one I have is 27. Do you want me to go like numerically on your docket?
Sure.
Okay, or the easiest ones. Let's number 47 is just a motion to retain. We're just waiting for settlement documents on this one.
Okay, CL 194848-I Unifund CCR versus Rafael Fondon. So you're just waiting for settlement documents?
Yes, Your Honor. That's correct.
Okay, so I'm gonna set a tickler then for August the 26th.
Okay.
Okay, next.
The next one, Your Honor, is I believe the opposing parties here, Carla Pena. Yes, she's in the court, and this one it's a contested one, and she's here. It was supposed to go for mediation, and we've not been able to complete that.
Okay, what number is it on the court's docket?
51.
CL 210230-I Velocity Investments versus Jorge Pena and Carla Pena.
Yes, Your Honor.
Okay, so Mr. and Mrs. Pena, have y'all made contact with the plaintiff's counsel? You're on mute, or I can't hear you. Raise your volume or something. We can't, I know you're not on mute, we just can't hear you. So I'm not sure. Try disconnecting from audio and reconnecting.
Now, can you hear me?
Yes.
Okay, great. Sorry about that. I was saying that there's been a couple of changes with this case, Your Honor. There was an initial attorney, and after that, we haven't been. I know there was a mediation. They told us to find a person for mediation. Unfortunately, we did contact them, and there was a fee that we cannot afford. We were hoping to come to an agreement with the attorney. We've been trying to call them. There was a website that was provided last time, which is jbpayment.com. Unfortunately, that website does not allow us to make a payment arrangement plan. So we're just we're still looking for options. We do want to take care of this, but we need to talk to someone so we can make an arrangements. When the previous attorney was handling this case, his name was Robert McLaughlin. He said that he did not have any authorization to come up with a payment plan. They were seeking like the full amount. But you know, we want to take care of this, and we just want some options.
Okay. So I don't know, Miss, if they can't afford the mediator's fee. Miss Max Vasquez, I don't know, who do they speak to, or are you just gonna go ahead and set this for trial, or what?
I do have notation here that if the defendant did appear to give them a number with an extension, I don't mind resetting it out for whatever time you determine, Judge. I can give them the number right now with the extension to speak to someone, and by the next hearing, if we're not somewhere in the middle, move for trial.
Okay, go ahead. Do you have something to write with, Ms. Pena?
Yes.
Yes.
Okay, go ahead.
Okay, the number is 1-800-837-0109, and you're going to use option 5. And when you're ready, I'll give you your file number. Okay. Okay. 183-5265. You can use that to reference your file number with.
What was 5 the extension number, or you said option 5? But is there an extension or?
Yes, option 5.
Okay, and is there a name to talk to someone specifically?
They don't have a name on this one. I imagine whomever you talk to, the easiest way I would think is to use your file number so they can easily locate your situation.
Okay, all right. Well, we'll give that a try. I know we tried a number again last time, and it was like an automated system, but we'll keep trying.
Okay.
Someone. Thank you so much.
Okay, so what I'm gonna do is I'm gonna set you for a status hearing and give you some time to do that. You'll return on October the 3rd, and that setting will be in person, October 3rd at 9:30. That gives you plenty of time to try to see if you can get something worked out.
Okay. Thank you.
All right. If nothing further, we'll see you then.
Thank you. Have a good day.
Likewise. Okay, your next case?
Yes, Your Honor. The next one is going to be number 27.
CL 210335-I, Geico versus Corayma, Korayma Rios et al.
That's correct, Your Honor.
Go ahead.
Okay, thank you. We ask the court to take judicial notice of all documents in the court's records. Your Honor, this is a cause of action that stems from a vehicle accident where Geico, my client, is seeking a return on damages that were paid out from the policy against the defendant, plural. All of the documents required for this cause of action have been filed with the court, in which case we ask for judicial notice on all documents. This petition was filed on January 19th of 2021, return of service on February 19th of 2021. And since then, all of the other documents that have been on file, such as the business records affidavit, police report, the payment record, medical records, damage report, property damage report, have been on file as well. We've not had a response from the defendant, nor are they in court today, in which case we move forward with the request for default judgment. All other required documents have been included with that packet, to include the certificate of last known address, non-military declaration, Department of Defense report, the business records affidavit was previously attached, and the proposed default judgment. Today we're seeking this. I'm sorry.
No, I was just going to ask if that's on each of the defendants.
It's inclusive total. It's they're joined, yes.
Okay. So then Coraima Yaritza Rios, Coraima Rios, Coraima Rios, Carlos Alberto Ramirez, Carlos Ramirez, Carlos Ramirez. Okay. So the defendant's name's being called out 3 times, no response, no answer filed on behalf of the defendants. And the court is taking judicial notice of all the documents on the court's file and is granting the relief as requested and put on the record.
Thank you. And for the record, can I state the amounts in the sum that we are requesting, Your Honor?
Yes.
I have on my side the sum of $40,968.89, plus reasonable attorney's fees in the amount of $500, cost of court, and post-judgment interest at the statutory rate of 5%.
Okay. All right, your next case?
The next case, Your Honor, is, let me make sure I have this correctly. Is number 29.
CL 213572-I, A Plus Federal Credit Union versus Gilberto Sanchez Valdez.
That is correct, Your Honor.
Okay, Gilberto Sanchez Valdez, Gilberto Sanchez Valdez. Okay, go ahead.
Okay, thank you, Your Honor. This also is a breach, well, this is a breach of contract claim in which the defendant did enter an agreement for a closed-end note disclosure loan and security agreement for credit. They did default on the account with my client, and we have not received a response, nor is the defendant here present today, in which case we are prepared to move forward for requesting a final judgment.
Okay, the defendant's name was called out 3 times, and go ahead, put it on the record.
Thank you, Your Honor. We ask the court to take judicial notice of all documents in the court's records, to include the business records affidavit, certificate of last known address, military declaration, Department of Defense report, and the actual proposed final judgment. The petition and return of service have been on file for the requisite amount of time. And at this point, we are asking, an attorney's fees affidavit as well. Today, we are asking for a total amount of damages of $11,348.54, plus attorney's fees in the amount of $1,500, plus cost of court, and post-judgment interest at the 4.5% rate.
Okay, the court's taking judicial notice of all the documents in the court's file and granting the relief as requested. And I'll ask for that order to be forwarded to our queue. Go ahead.
Thank you, Your Honor. My final case is number 30.
CL 214019-I, Geico County Mutual Insurance versus Paul Anthony Basaldua and Patricia Torres. Paul Basaldua, Patricia Torres, Patricia Torres. Go ahead.
Thank you, Your Honor. We ask the court to take judicial notice of all documents in the court's records. This is also a claim for property and medical damages that my client assumed the responsibility and is requesting a judgment against the defendants for the recover of those amounts. All requisite files have been filed with the court for the requisite amount of time. The return of service has been on file for the requisite amount of time. We have not received a response from the defendants, nor are they in court today, in which case we are ready to move forward with the final judgment.
Okay, the name being called out 3 times, no response. Go ahead.
Thank you, Your Honor. In the packet, along with the proposed final judgment, would include certificate of last known address, a Department of Defense report, the non-military declaration, the medical, the police report, the medical damages and property damages reports. And what we are asking for today are going to total property damages in the amount of $12,385.37. We are not asking for any medical damages, and we do have a deductible amount of $1,001. The total will equal $13,386.37.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that service was perfected. The defendant's names were called out 3 times and no response. The relief as requested is granted. And I'll have that order submitted to my queue, forwarded to my queue.
Yes, ma'am.
Okay, anything else?
That's all I have today, Your Honor.
Okay, Ms. Peña, you came back on. Did you need something from the court or from plaintiff's attorney?
Hi, I was wondering if I could get a phone number from Ms. Max Vasquez, because we're trying to reach someone right now, but we keep saying, just leave a voicemail for them to contact us back.
Sure, go ahead. You can reach me at my office 956.
Okay.
443.
Okay.
0043.
Okay.
And I will look more into this. I will send a report over to my client and see if I can get a better number or contact information from you.
Okay, sounds great. Thank you so much. I appreciate it.
No problem. Have a good one.
You too.
Okay. Thank you, Ms. Max Vasquez.
Thank you, Your Honor. May I be excused?
You certainly may.
Have a good afternoon. Thank you.
Likewise. Okay. What number was this again?
Number 34, Your Honor.
All right, CL 21-4285-I, Maria Maribel Benitez versus Blue Chip 2000 Commercial Cleaning, Inc. And this is Mr. Quesada's motion.
You're on mute, Mr. Quesada.
Thank you. Sorry about that. Yes, Your Honor.
Okay, all right, so we have about 15 minutes.
Try to be as brief as possible.
Go ahead.
Your Honor, we're here on defendant's traditional motion for summary judgment based on the affirmative defense of statute of limitations. This case is a slip and fall, which according to plaintiff's medical records in the incident report occurred on December 29th, 2019. The plaintiff is alleging personal injuries, thus the applicable statute of limitations is 2 years. Plaintiff did not file her lawsuit until December 30th, 2021. Therefore, that is after the statute of limitations expired. For that reason, defendants are seeking the traditional motion for summary judgment.
All right, Ms. Cedillo, your response?
Yes, Your Honor. While it is our position that the incident happened on 12/30 of 2019, that was what we were informed by our client. We provide how the initial contract with our client and whatnot. Then also what we ended up doing is my client submitted an affidavit of her understanding that the incident occurred on 12/30 of 2019, thus making the statute of limitations 12/30 of 2021. She filed the affidavit. Originally with defendant's motion, one of the first exhibits that they submitted was an incident report, an unauthenticated, not certified report that was hearsay. And then when we attacked that incident report, because the exhibit A to their first motion had no identifying factors, none whatsoever to our client, and after they had already certified that that was a true and complete copy of the document, then they went and refiled a new incident report that said, oh, wait, no, this is actually the true version of the document in their response, their reply to our response. So you had a one-page incident report with no identifying factors. Then you now have it. Now, in regards to the medical records, Your Honor, My client stated in her sworn affidavit that she did not fill out the medical records. That the medical records from those providers were already noted. You know as well as I do, Your Honor, that medical records many times have mistakes. There's one provider that gets a date, they send it when they're referring it to other providers. So therefore, that's the day of incident. In regards to the actual concern, my client testified that the record was already provided. She was just told to sign at the bottom to indicate that she attended treatment that day. The medical records, as opposing counsel stated earlier, that this is a slip and fall case, the medical records actually also sometimes refer to this as a motor vehicle accident. So there are mistakes within records. It happens very often within cases. Now, in regards to those arguments, that's the first one, that it's our position that the accident happened on 12/30/2019. But in the event, for the sake of argumentation, had the event happened on 12/29/2019, we understand that the limitation then would have been 12/29/2021. Our petition was filed the day after. Now, during this time, it was after the Christmas season. It was the height of COVID. COVID did play a big role in this case. I know that half of my staff was out after the holiday surge of COVID that hit Texas, that second surge wave. But if you look at the actual orders that have been filed in the past regarding to the tolling of statute of limitations and the positions that people can take, while we do have the first order that was released by the Texas Supreme Court on March 13th that says that the court may extend an SOL for a period of 30 days until the Texas disaster had been lifted. We take the position that yes, it was modified later. It was readdressed in the 8th order, and the 8th order, which was released on April 1st of 2019, states that the actual cases and the statute of limitation for those periods of time, that it was told. It was told. They specifically used the word told in that order. Now, told, Your Honor, as you know, means that it is a suspension period. So for that time, because they didn't previously toll it on their March 13th order, they used the tolling language on their April 1st order. Now, when they revised the order again, they released a new order, the emergency 12th order on April 27th, that is when they did use the language that it may be extended. Thus, if you look at the history, we have the case laws where the cases are tolled for 27 days nonetheless during that time period. A tolling period, it's not extended, it was tolled. An extension is different than the actual tolling of case. The tolling means that you can add those dates onto the actual cause of action. So then you have our previous history of the tolling argument for the 26 days that would have added on. If, say, for the sake of argumentation, that the accident happened on December 29th of 2019, if you had added the tolling argument or the tolling amount of time, which was the 26 days that was granted by the 8th order and the time between the 8th and the 12th emergency order, then that would have made the statute of limitation for this case around mid-January of 2022, which our petition was filed within that time period. And Your Honor, I understand that opposing counsel has cited a case in regards to try to state that the argument that we're applying to the emergency orders does not apply, the Porch versus Daimler trucks. However, that particular case within itself is an appeals case, and the tolling, all emergency orders have always said that the extension or that the tolling of any orders, anything like that, does not apply to appeals case at any time. There has been no argument or anything that says, oh, you know what, this is going to apply to all civil cases. The orders were very specific to state that it does not apply to appellate procedures. So therefore, your argument, that case that they cite in their reply is not applicable to the argument itself.
A response?
Yes, Your Honor. So I'll address them in the reverse order. As it pertains to the COVID orders, I think the court, by the time that this lawsuit was filed, we were at the emergency order number 46. At that time, it was clear that the only extensions granted for statute of limitations for filing and serving in civil cases was from March 13th 2020 till September 1st of 2020. There were multiple orders issued throughout that time. I mean, it's not like it's as if after that September 1st, extending to September 15th, continue to issue orders extending the statute of limitations deadline. It was very clear that there's been at least 25 orders since the time the last extension was granted as to the time that the plaintiff filed this lawsuit. With regard to the incident report, we've produced discovery in this case, as plaintiff's counsel knows, and we've bait stamped the complete incident report, bait stamp number blue chip 000114 to 1117, which was produced months before we even addressed this. The motion for summary judgment was even filed. So it's not like it's a surprise that there was more than one page of the incident report. It's been clear, it's been multiple pages. It's clear that it identifies the plaintiff not only by name, by Texas driver's license, Texas identification card, ethnicity, weight, height. I mean, I think there's not an issue that the incident report is related to the plaintiff. In addition, as it relates to the medical records, yes, there may be mistakes, and I'm sure that's not Ms. Benitez's fault, but the fact that there's not a single medical record that says that the plaintiff's incident occurred on December 30th of 2019. To the contrary, it actually says exactly 37 times that plaintiff's incident occurred on December 29th, 2019. So I don't believe there's an issue there at all.
Okay, well, I can tell you that this is going to be well, did you first, Ms. Cedillo, did you want to reply or anything?
Yes, Your Honor. Just for clarification on the record, it still does not dispute, there's no argument in regards to the incident report is still not an authenticated certified report. There's still the possibility that it could be tampered with. We have the issue to where there's still hearsay based off the report. And not only that, but the 40th emergency order, which we are not talking about, but just for the sake of clarification on the record, it extended it not until September 1st, but actually October 1st of 2021. We're focusing more on the wording that was used on the 8th word, the toll. And then also in regards to the argument with the medical records, as we stated, Your Honor, many times these providers, they get a date, and then when they just defer the referrals, that's what they go based off of. And that is what we're indicating, because all those times that he's discussing about how it has the date listed, none of those times are written in my client's own handwriting.
Okay, so what I was going to say is that this is going to be very interesting for me because it's the first case that I have to deal with respect to having to deal with the possibility of tolling the statute of limitations, and with the arguments that Mr. Quesada has put forward and the arguments that Ms. Cedillo has put forward. So rest assured that I will be paying very close attention to your motion and the responses and any replies. So is there anything else that you want me to consider except what's on file and what you've already argued today?
Your Honor, if you'd like, in response to our motion, we listed that at the time of the week of filing that more than half my staff was out with COVID. Because it was during a COVID surge, I did not include any copies of their actual positive tests, only because to preserve my staff's privacy. I don't know if that's an issue, because I do know that one of the main things with the tolling and why it was concerned is because you had issues during all the times where the offices were reduced in staff.
Right. Okay. All right. Well, I'm going to still go ahead and I'll look at everything. And so I'll give myself some time. So I'm going to take this under advisement, and then I'm going to go ahead and review everything very carefully and have your competing orders on file, please.
Yes, Your Honor.
Okay. Anything else?
No, that's it, Your Honor. That concludes our business. May we please be excused?
Mr. Quesada?
Yes, I do. I just want to, for purposes of clarifying with the client.
Sure.
Do we have an somewhat expected date on we should expect an order be signed, either one way or another?
Well, normally I do try to get this done within 30 days, but it's also during this time period where vacation is taken. So it's you probably won't hear something from me until about August, in all reality. Okay?
Thank you, Your Honor.
Thank you, Your Honor.
Okay, just make sure you have your competing orders on file.
Yes.
All right. Okay, thank you.
Thank you.
Thank you, Your Honor. May I be excused?
Yes, you may.
Mhm.
Thank you, Your Honor.
Okay, in reviewing the docket, was anything submitted for number 18, CL 186177-I? No, this doesn't have anything to do with you, Mr. Quesada.
Yeah.
Yes, ma'am. I see a Rule 11 and an order resetting filed.
Okay. Number 36, CL 143510-I, did anybody call in?
Give me 1 second, Judge. No, ma'am.
Okay, go ahead and set that for the drop. Number 57, CL 213988-I.
Checking, ma'am. My computer is slow, Judge. Hold on. It's still spinning. No, ma'am, nothing.
Okay, set that on the drop docket. On CL 220346-I, I see that it did settle. Has the settlement documents been filed?
Checking. It says that there was an order granting the dismissal filed today, ma'am.
Okay. And then 61 F 1091-21-9. Nobody showed up. Go ahead and set that on the drop. F 4336-21-9. That's also pro se. No one showed up, and set that for the drop. Okay, that concludes this morning's docket.